The Rules Committee will come to order. This is a sad day. When our founders drafted the Constitution more than 230 years ago, they included a process that could lead to removing a president from office if he or she abused their power. That is what separates America from so many other nations. There are no kings or queens here, and no one is above the law. That process, impeachment, is rarely used because of its seriousness. In fact, this will be only the fourth time in our nation's history that Congress has considered the presidential impeachment process. And in the case of President Nixon, the president resigned instead of facing likely impeachment by the House and removal by the Senate. It is a solemn responsibility. This Congress, with our existing authority under the Constitution and the rules of the House, is in the midst of an impeachment inquiry right now. No one runs for Congress to impeach a president, but we are here today because the facts compel us to be. There is serious evidence that the president may have violated the Constitution. Unlike during the impeachment of President Nixon and Clinton, no special prosecutor has been named to investigate President Trump on this. There is no single report from which this Congress can make a decision whether or not to impeach President Trump on his dealings with Ukraine. That's why the Intelligence Committee has been gathering evidence and hearing testimony. Reasonable confidentiality has been paramount so that accounts couldn't be coordinated and witnesses weren't unduly influenced. It's a process, by the way, that even former Republican Representative Trey Gowdy, who chaired the Benghazi Committee, has endorsed. He said, and I quote, "I think if you're going to have private investigations with unlimited time for questioning and cross-examining witnesses, that's a good thing," end quote. I agree, and I'm proud of our deliberative process so far. Now, as committees continue gathering evidence, they are preparing to present their findings. As we enter the public-facing phase of the inquiry, I introduced a resolution yesterday to ensure a clear path forward. We are marking up that resolution here today. I don't know whether President Trump will be impeached. Only the facts and how we respond to them will dictate that. But I can tell you this. This process determining whether he should be impeached will be open to the public view, just as it should be. Now, I know some Republicans are very resistant to investigating the president at all, but that will not stop the American people from hearing the facts. A group of Republicans even resorted to storming a secure facility to disrupt witness testimony. That's despite the fact that many of those members were already entitled to attend the deposition. So let me tell you, I mean, I believe in civil disobedience. I've even been arrested protesting for what I believe in. I've protested for human rights, and I've protested against gun violence. But endangering our national security and compromising a secure facility is a whole other matter. Bringing cell phones into a secure area and tweeting and recording, I hope we never see anything like that again. But I want to make this clear right at the top of this markup. I appreciate the way members of this committee treat each other with respect and always display professionalism. And that certainly includes our minority and ranking member, Tom Cole. I think the Rules Committee, week in and week out, sets a good example of how members should treat each other. And I hope that tradition continues today. We all feel strongly and we all feel passionately about the matters before us. And I expect that will be reflected in today's proceedings. But I respect everyone, and I appreciate the ranking member's commitment to this institution and to doing what's right, as I do with every member on both sides of the aisle. As much as I disagree with this president and don't like his tweets, his tone, or his policies, I never wanted our country to come to this point. But 5 or 10 years from now, people will ask each of us what we did in this moment. They will ask us what we did when confronted with this crisis. And let there be no doubt that as much as this president flaunts the Constitution, we are going to protect it. We will stand up for the Constitution and defend the rule of law. And now let me turn to our ranking member, my friend from Oklahoma, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. And just let me begin by frankly reiterating what you said in terms of keeping this process civil and professional and fair and open. I agree with another sentiment you expressed, and that this is a very sad day. It's a sad day for me personally. And I doubt anybody here ran for Congress with the idea that they would ever be involved in an impeachment inquiry. I certainly never thought I would be. I think it's a sad day for the Rules Committee and for the institution of the House of Representatives. We're meeting here today to set forth a process for impeaching a president of the United States. In my view, it's not a fair process, it's not an open process, and it's certainly not been a transparent process. It's been limited and closed result. Over the last occasion, what's been called a formal, of course, there's nothing formal about it other than the Speaker saying so. The House has never voted to conduct such an inquiry, and the committees have operated in the dark without formal authorization on what amounts to nothing more than an expanded fishing expedition. At least today, in my view, the majority is admitting what we all know. That's that the House was not following an appropriate process for impeachment. I do not think the process we're setting forward, frankly, with all due respect to my friend, the chairman, in this resolution is a fair one either. It's not fair to the President of the United States. It's not fair to the people of the United States. The process laid out in the resolution before us is different from the processes used for both President Nixon in 1974 and President Clinton in 1998. Both presidents were given substantially more due process and protections than what the resolution gives to President Trump today. In the case of President Clinton, that was a Republican House of Representatives affording a Democratic President of the United States more due process than the current Democratic House is affording the current Republican president. First, frankly, both Presidents Nixon and Clinton were given the right to have counsel present to review documents and materials presented to the committees, to recommend witnesses, to cross-examine witnesses when appropriate. Counsel for both presidents were fully participants in the Judiciary Committee hearings and were allowed to make arguments. And more importantly, in both cases, the president's counsel's request for witnesses to testify was accommodated. That's certainly not been the case thus far in this process. Today, and in today's resolution, there's no right for President Trump to have counsel in any of the depositions, hearing, or inquiries that have been conducted thus far. So we're well into the process without the president having been given the right to actually participate in it. The resolution includes nothing that would give him that right going forward. On a matter as serious and solemn as this, we cannot leave important factors like the right of counsel to the whim of a committee chair, which is exactly where it would fall under this resolution. Second, in both the Nixon and the Clinton impeachment proceedings, the minority was given the co-equal right to subpoena witnesses and documents. The purpose of this was to ensure that the investigations would be fair, impartial, and bipartisan. Today's resolution differs from the Nixon and Clinton precedents in a key way. The resolution does not provide for co-equal subpoena power. Instead, it grants the minority the right to subpoena witnesses and materials only with the concurrence of the chair, and the requirement that such subpoenas be, quote, deemed necessary to the investigation. That's a heck of a situation when you get to decide what is necessary for an investigation. There was no limitation in the Nixon and Clinton impeachment proceedings that was similar. As a simple matter of fairness, it's important to note that there are no such limitations on the committee chair. If this is truly a bipartisan process, why then is the minority subject to such restrictions on its ability to participate while the majority is certainly not? I think the differences between the procedure and the procedure followed in the past are very clear. Today's resolution fails to give the president the right to due process that Presidents Nixon and Clinton enjoyed, and it fails to preserve the right of the minority to fully participate in the proceedings. This resolution also differs from the Nixon and Clinton resolutions in another key way. Both of those previous resolutions were written in a bipartisan manner and with full consultation with the minority. We were not involved in any way in the construction of the resolution that we are considering today. It was dropped on us with 24-hour notice. This committee has not had a hearing about the procedures and how we should go. We simply are presented with this sort of full-blown out of, or fully made out of whole cloth. This resolution, frankly, again, is not bipartisan and done with full consultation with the minority. It was written only by Democrats without even a pretense of consulting Republicans. I didn't even see a copy of this thing, this resolution, until it was released publicly. Mr. Chairman, we can certainly do better than that and better than we're doing today. When President Nixon, President Clinton were impeached, the process was a collaborative one. The minority was allowed to participate fully and equally. The president was given the right to have counsel present and participating. That preserved the rights of the minority, preserved the rights of the president, and ensured that due process was the touchstone for the House. Without due process and without a fair process that respects minority rights, I do not believe the American people will regard this process as legitimate. A legitimate process is one that offers protections for everyone involved, and without those protections, this will be seen as just another partisan exercise, one the majority has been pushing towards since the very first day of the 116th Congress. That's unfortunate, and I hope we can do better than that, but certainly look forward to the hearing today, and we intend to participate as fully as allowed.
Thank you. And I appreciate your comments, and I'm sure it comes as no surprise to you that I disagree with your analysis of the protections and the rights we are affording the President of the United States. But I do feel compelled to just state for the record that if we're going to talk about process, we ought to respect and the constitutional authority of the House of Representatives. And this White House, and it's one of the reasons why we're here, has obstructed our investigations, ignored our duly authorized subpoenas, withheld key documents, prevented witnesses from testifying, and intimidated witnesses. They have tried to disparage members of Congress who are trying to fulfill their responsibilities under the Constitution of the United States. And I just, for the record, will say Article 1 of the Constitution gives the House the right to investigate the President. And we are taking our responsibilities seriously, and that's what this resolution proves that. The measure before the committee is H-Res 660, directing certain committees to continue their ongoing investigations as part of the existing House of Representatives inquiry into whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Donald John Trump, President of the United States of America, and for other purposes. Without objection, the resolution is considered as read and will be open for amendment at any point. Are there any amendments to the resolution?
Mr. Chairman?
The gentleman from Georgia, Mr. Woodall.
Are we going to have an opportunity to read through the resolution, ask questions of counsel about it?
If you want,
I don't want to read it just for the purposes of having it on the
read the
record, but I
resolution?
did have some questions about the text and how it was drafted and why it was drafted in certain ways. I know on the Budget Committee, we would go through line by line. We don't do original jurisdiction hearings that
well, we can go through line by line if you like.
And would there be a counsel available to answer questions about the draft?
We can do that. I'm sorry. I mean, this is not a hearing; it's a markup. We can go through line by line, and you can offer your amendments, and we can have a discussion based on your concerns. I assume that you're offering amendments.
Well, I do have amendments, but
I yield to the gentleman from.
So point of order, if we go line by line, will we have to amend to that line at that point?
Yes, you would.
well,
It's by section.
I'm burdened by being primarily a Rules Committee member, and we don't primarily do original jurisdiction. In my time on the Budget Committee, for example, we would read through the budget line by line to answer members' questions about particular line items, and then we would come back and have those amendments done in an order. There are things in here in my decade in Congress that I've never seen done before, and I'm sure there's a good reason for it, but I don't know if I want to take it out or not, if the majority can explain to me why it's in there and how it advantages
The gentleman is recognized, and he may offer his amendment, and we can discuss it, based on what you want to add or what you want to subtract. You may want to reconsider your amendments after you offer them.
I take the gentleman's point,
right.
and the answer being that we will not read through it, but I will offer the amendments as I have them. I would say, Mr. Chairman, I have an amendment at the desk.
The gentleman, the clerk will report the amendment.
Amendment number 1 to House Resolution 660, offered by Mr. Woodall of Georgia. Page 1, line 1, strike that and all that follows through page 6, line 16, and
Mr.
insert
Chairman?
the following.
I'd ask permission that the unanimous consent that the amendment be considered as read. What I would tell you is it's going
Without objection.
to strike everything except for Section 4 that structures the Judiciary Committee and the impeachment inquiry as the Judiciary Committee would have it done. Mr. Chairman, the reason I was asking about reading through and trying to understand it, I mean, the resolved that all of these committees that are already investigating are going to continue their investigations, I don't understand what that means in the context of moving forward. We're going to authorize folks to continue doing something that we've never authorized folks to do before. What I would say, because I take the chairman's words at face value, he was talking about Republican obstructionism in his opening statement, but he said this will not prevent the American people from hearing the facts. I would say to my colleagues that if we keep the Intelligence Committee section of this resolution intact, the secrecy of that committee will in fact prevent the American people from hearing the facts. What my amendment would do is strike all of the Intelligence Committee language to recognize, as we did in the Nixon impeachment, as we did in the Clinton impeachment, that this is a function of the Judiciary Committee, and include, as the majority has drafted it, the Judiciary section. Now, to be clear, that Judiciary section is not as fair and equitable to the minority as the Clinton Judiciary section was. That's a different argument for a different day. I recognize the majority has the right to allow or limit voices as they see fit. But I would encourage my colleagues, a bifurcated process that continues to happen behind closed doors does nothing to achieve the goals the chairman has laid out. I don't believe the majority has anything to hide, and I'm certain the minority has nothing to hide. And so let's eliminate this ability for the Intelligence Committee to continue operating behind closed doors, move it to the Judiciary Committee, where we have always done that as a nation in the tragic times where this House has chosen to go down that road. And so when, as the chairman proposed, that folks are asking the question 5 or 10 years from now about what we did in this moment, we ensured that we did protect the constitutional prerogatives of Article 1 and of Article 2, such that we could, even in a tragic time, be proud of the way this House operated.
I yield to the gentleman from Maryland, Mr. Raskin.
Mr. Chairman, thank you. I want to speak in opposition to the gentleman's amendment, as thoughtful and as well-intentioned as it is. The first thing that we need to clear up is that everything that has taken place in the investigations by all of the committees in Congress has been perfectly constitutional and perfectly lawful. And you have to look no further than a decision last Friday, October 25th, by the United States District Court for the District of Columbia, Chief Judge Beryl Howell, who said it is solely within the power of the House of Representatives to conduct impeachment proceedings. It is solely within the power of the House of Representatives to design our own rules. And we have the power to get the information that we want in the manner in which we want to get it. So this period of the investigation differs from the Nixon and Clinton investigations only in the sense that there were special counsels in the Department of Justice who did the closed-door deposition phase in those investigations. There were lots of closed-door interviews, depositions, investigative materials being shared and so on in both the Nixon and Clinton investigation, with Archibald Cox in the Watergate case and with Ken Starr with respect to Bill Clinton, and nobody objected to that. This Department of Justice refused to do an investigation into the alleged misconduct and criminal operations of the executive branch of government. Therefore, it was left to the legislative branch to do it. That's precisely what our investigative committees have been doing. And so it is already established that it is perfectly lawful, perfectly legitimate. We continue to recognize its legitimacy as they continue, but it seems to me what you're objecting to is the opening up of the process, because that's what it is now. We are ready to move to an open process where the public will be able to see the witnesses and to get the facts, and everybody will have access to it. So I don't know, or put it this way, I would reject this because it's an attempt to shut down the opening up of the process so the whole public can see precisely what's been taking place behind closed doors. I yield back, Mr. Chairman.
I appreciate the gentleman's comments, and I agree with everything he said. So perhaps either I didn't explain my amendment properly, or we're confused about what the underlying legislation does, which is why I was hoping we'd have counsel here to explain the legislation. There is nothing that the Intelligence Committee is authorized to do in this resolution that the Intelligence Committee isn't doing already. The Intelligence Committee isn't opening up to allow the President to come and ask questions in the Intelligence Committee. The President will be completely excluded from the Intelligence Committee procedures. If, to the extent that the majority wants to investigate the President, to the extent the U.S. House of Representatives wants to investigate the President, that's absolutely our constitutional prerogative. My question is, why in an impeachment resolution are we authorizing the investigative process that would traditionally, exactly as the gentleman from Maryland.
I got you, Mr. Woodall. I think I can answer it, but maybe the chair could help too. I believe that the procedural change here is to change the 5-minute rule so that there could be an open hearing and there could be professional staff questioning in an open hearing of the Intelligence Committee. But I'll yield to the chair on that.
Yeah, no, and I would just say that the gentleman's amendment would strike the provision that would require the Intelligence Committee to have an open hearing, but I'll yield to Ms. Torres.
I want to enter for the record HRES 507, which was taken up by the House, which allowed these committees, and it confirmed for these committees to give them the authorization to be able to have subpoena power. This was the beginning, and now that those classified briefings are coming to the end, it is only correct that we move forward with an open process, and I hope that we will continue to come to the House of Representatives for a formal information on how to proceed. So I would like to enter this
Thank you.
for the
Without
record.
objection. I hope the gentleman is not inferring that Republicans on the Intelligence Committee have not been part of the
Not at all.
being there when the depositions were taken.
I would certainly say that the ability to answer questions in the environment that we are currently seeing the investigation take place has certainly been truncated. But I was not. My suggestion is that if this is the official phase of the impeachment inquiry, my friend from California said, "Isn't it wonderful that the language that Woodall proposes to strike would require that there be at least one public hearing?" Folks, if this is the time that we're beginning an impeachment inquiry, this is the time to refuse to allow even one non-public hearing. If this is the time for openness, let us declare that everything will be open going forward, which we do through our colleagues here who serve on the Judiciary Committee.
I yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. I have a question for my good friend from Georgia. Under the resolution as it's written, is the president represented in the Judiciary Committee? Does he have the ability to have counsel to cross-examine, deposition, et cetera, et cetera? Is that true?
In the resolution as the majority drafted, HRES 660, only in the Judiciary
Well, that
portion.
was my second question. So I'm assuming that, yes, the answer is yes, he has it in the Judiciary Committee. Does he have it in the Intelligence Committee?
As the majority has drafted the resolution, the president has no ability to ask any questions or call any witnesses in the Intelligence.
Does he have it in any other of the committees that have been pursuing impeachment inquiry?
As HRES 660 is drafted, mentioning financial services, foreign affairs, judiciary, oversight, reform, ways and means, and intelligence, the president has no ability to participate in any way in any of those committees.
And to my friend's best recollection or knowledge, was that the case for President Clinton or President Nixon? I mean, were they represented in the Committee of Jurisdictions where the hearings were taking place?
Well, again, the majority can draft it as they see fit, but your vision is mine. HRES 581, as passed by the Republican House in 1998, only named one committee of jurisdiction. In that one committee, gave the president and his counsel full ability to participate. In fact, as I recall, there were only 4 hearings held. 3 of them were held at the House's request. One of them was held at President Clinton's request, calling only President Clinton's witnesses at that time.
And so that wouldn't be possible under this procedure?
It would be impossible in all of those committees that I have.
Thank you very much. Thank you, Mr.
No,
Chairman.
I would just say before I yield to Ms. Lesko that if I remember correctly, Ken Starr did the investigation under Clinton, and then that report was then sent to the Judiciary Committee, where the president had rights. Here, the Intelligence Committee is doing the investigation. So in any event, Ms. Lesko.
Thank you, Mr. Chair. I want to say that I support Representative Woodall's amendment, and for some of the same reasons that were already mentioned, but I kind of went line by line through this, and the title of Section 2 is very misleading. It says open and transparent investigative proceedings. This is not open and transparent in the Intelligence Committee. I mean, all it's doing is saying we're going to do the same thing. In fact, I'm on page 2 and lines 15 through 17, and it says require an open hearing, and which was stated before. That could be one open hearing. We don't know how many closed-door hearings there are going to be from now on, that nobody, including myself, who's a member of the Judiciary Committee, can even attend. And the other thing is that it still allows Chairman Schiff to instruct witnesses not to answer Republican questions. So that came out yesterday. I mean, one of the Republican members asked a question of the witness, and Mr. Schiff told the witness, don't answer that question. I mean, that's just wrong. And then on page 3, I have lines 21 through 25. It also lets Chairman Schiff determines if Republican witnesses' requests are relevant. You know, I mean, that's not fair. How about on page 4, lines 1 through 4? It says basically that Representative Nunes, the ranking member in Intelligence, needs permission of Chairman Schiff to subpoena witnesses, unlike what has happened in the Nixon and Clinton impeachment hearing.
Will the gentlelady yield?
And I will when I'm done. Thank you. And then on page 5, lines 3 forward, I wrote, Chairman Schiff is not required to make public all transcripts. He can pick and choose, or he can choose not to make any transcripts public. And then Adam Schiff determines what he deems appropriate to include in his report. I mean, if you think this is fair, this is not fair at all. And so the title of this is really misleading to the American public. I went to that Storm the Ship.
Right.
I was one of the
Ship,
people.
right.
Now, I did not go inside because I actually had a bill in Homeland Security Committee to go to. But I also went previously and asked, can I see testimony? Can I see testimony? I'm a member of the Judiciary Committee, and I'm going to be voting on this in Judiciary Committee, yet I can't even see the testimony, as has been done in both Republican and Democrat leadership in the past under the Nixon and Clinton impeachments, where it was done in the Judiciary Committee. It was open. It was open to the public, and you said Ken Starr.
Yeah, absolutely.
Well, he's an independent counsel. I'm sorry, Adam Schiff is not an independent counsel. In fact, he has made repeated statements over and over and over again that he wants to impeach the president. He's very biased.
Last time I checked, DOJ didn't appoint a special counsel in this matter, so we're left to do it. I just will point out to the gentlewoman that I'm looking at the resolution here. It says the chair of the Permanent Select Committee shall designate an open hearing or hearings pursuant to the section. Under the Woodall Amendment, you strike that, and we maintained the status quo. So I think I would urge a no vote on the Woodall Amendment.
Mr. Chairman, just make sure we're on the same page. You would also agree that the status quo is that the chairman of the Intelligence Committee can open up have as many public hearings as he would like. The requirement that he have at least one is new. The opportunity to have them all be open is present today without this resolution.
Well, in my opening statement, I went through why some of these hearings have to be closed. I also went through a list of all of the things that the White House has not cooperated with Congress on, and I'm really a little bit stunned that members of Congress aren't more upset about the fact that, our constitutional rights are being totally ignored by this president. But having said all of that, I would urge a no vote on the Woodall Amendment. Any other comments? If not, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, can I get a roll call vote?
Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings? No. Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon?
No.
Ms. Scanlon? No. Mr. Morelli? No. Mr. Morelli? No. Ms. Shalala? No. Ms. Shalala? No. Mr. DeSaulnier? Mr. DeSaulnier? No. Mr. Cole?
Yes.
Mr. Cole? Aye. Mr. Woodall?
Aye.
Mr. Woodall? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Mrs. Lesko? Aye. Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk, report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Any further amendments? Mr. Burgess.
Thank you. I have an amendment at the desk.
Clerk will report the amendment.
Amendment number 2 to House Resolution 660, offered by Mr. Burgess. Page 1, line 2, strike financial services. Page 1, beginning line 3, strike oversight and reform and ways and means, and insert oversight and reform.
Am I recognized on the
The gentleman is recognized. I'm sorry.
So, as you heard, this amendment strikes references to the Committee on Financial Services and the Committee on Ways and Means in Section 1 of the resolution. To me, it is unclear why these two committees are included in the list of committees directed to continue the ongoing impeachment investigations, because the only reason for including these committees in the impeachment investigation is to access President Trump's personal business papers and his IRS papers. We know that Democrats have sought this information since the time that this president was nominated by his party in July of 2016, and that crusade has been relentless ever since. However, the goal is beyond the scope of this whistleblower complaint that led to the announcement of the impeachment inquiry. This is continuing a fishing expedition to see if we can't find something on which to impeach the president. It is not part of the complaint that I believe Mr. Schiff has brought to us surrounding the whistleblower. So no reason to include these committees in the impeachment investigation. I'm sure they'll welcome us giving them the time back that would otherwise be consumed by this, and really this is nothing more than a fishing expedition to see if they can't uncover something else that might be useful to them should the whistleblower complaint fail, which I believe it will.
Thank you very much. Some people call it a fishing expedition like you. Others call it congressional oversight. I want to yield to Mr. Perlmutter, who's also on the...
So I would just say to my friend from Texas that this is not a fishing expedition. In fact, the federal courts have said to the administration and to President Trump, turn over the documents. Turn over the documents on your tax returns and turn over the documents related to Deutsche Bank as it pertains to any monies that came from Russia. And despite orders to turn over those documents by the federal courts, the administration continues to withhold them. And so I would say to the gentleman, this is not a fishing expedition. If anything, it's an obstruction but in turning over documents legitimate to the review by this Congress.
Does the executive branch not continue to have appellate rights on those court decisions? This is still being litigated, as I understand it, is it not?
The orders from the D.C. Circuit and from the federal court in New York have been entered, and the gentleman, the administration continues to appeal. You're right.
They continue to exercise their right to judicial review under the Constitution.
They do. And we continue to request those documents, and the orders so far are to turn them over.
However, the administration has asserted its right to have that litigation continue and to appeal those decisions, and I expect, and you're the lawyer in the room, I'm not, but I would expect that will go to the highest court in the land.
And the gentleman may be right, and it is the Congress's prerogative that you're trying to strike by your amendment, that we discontinue that. And so I would say to the gentleman that I'm going to certainly vote against your amendment, because these requests, which have in effect been supported by the courts, are legitimate, and the requests that we've made continue to pursue are legitimate.
If the gentleman will yield, I will just simply point out that this process has already been enjoined, and the president is exercising his appellate rights, as is his right, as would any other citizen have that right, and there's no reason to exclude that right from the president. When the case is finally litigated, you may get what you desire, you may not. But I don't see the value in including it in this resolution that we're hearing today. It's almost as if we want to give our blessing to perhaps further the case against the president of the courts. I don't think that's the purpose of this resolution.
And I appreciate the gentleman's thoughts. There is value here, and certainly the continued pursuit of these documents is within the prerogative of the Congress, and that's why I would ask my colleagues to vote no on your amendment.
Mr. Raskin.
Yeah, just to echo Mr. Perlmutter's point, under Article 1, we can shape our impeachment investigation however we like. And so oversight is part of it, and Ways and Means are part of it, because they have relevant evidence to bring forward, and all of them will be sending evidence to the Judiciary Committee of potential high crimes and misdemeanors. Now, to put your mind at rest, I believe that the litigation relating to the president's taxes took place before there was an impeachment investigation. I don't think it's related to the impeachment investigation, so, which isn't to say we couldn't request it, but so far I don't believe it's been requested as part of the impeachment investigation. So, look, some presidents would take only one committee to investigate their potential high crimes and misdemeanors. Other presidents may need multiple committees to be working on all of their high crimes and misdemeanors. So if it's a fishing expedition, there are a lot of fish, and there might even be some whales out in the water there, and I also would resist this amendment.
Will the gentleman yield for a question?
Sure.
Why then is not this information turned over to the Judiciary Committee as it is in the other portions of the resolution?
Wait, which?
The Ways and Means and Financial Services findings.
So is there something that prohibits them from turning the
All the
evidence over?
committees are instructed to turn their information.
I thought that was precisely how it's set up.
They're authorized to.
I-
They're authorized
If
to.
I could just get pointed for me, the page and line.
I think the precise point of doing this is to say that all of the investigatory committees will turn over their evidence to the Judiciary Committee, which will have the difficult job of synthesizing the potential high crimes and misdemeanors of this administration.
Mr.
McGovern?
Oh, yeah,
yield back.
Mr. Hastings, that's you.
I always learn from Mr. Hastings. I would be happy for him to.
Well, I just want to lift from the amendment as offered by Dr. Burgess to strike line 1 and also line 3, dealing with oversight and reform and Ways and Means and oversight and reform, as it says. The language in the resolution reflects the following. That the various committees that are identified have ongoing investigations as part of the existing House of Representatives inquiry into whether sufficient grounds exist for the House of Representatives to exercise this constitutional power to impeach the President of the United States. Those ongoing investigations are what are relevant at this particular time, and they will all, once completed, be turned over to the Judiciary
I would
Committee.
submit that then, when they reach their conclusions, then perhaps we would consider another such resolution, but to include them at this point, when it is not part of the whistleblower complaint, to me, it has the effect of broadening the scope in a way where the president has no means of defending himself against these allegations in really any of these committees.
Dr. Burgess, when was the last time you saw a crime suspect in a grand jury?
I can't tell you that, I mean, I'm not a lawyer. I don't go
Yeah,
to
I can
jury
tell you.
proceedings.
That simply doesn't occur. What we have to take into consideration here is that.
Are people being impeached by grand juries these days?
No, but I'm likening the
Well, you
grand
can
jury
liken it to the
process
procedure,
to
but this is a
this
unique
particular
procedure.
process. Of course it is. And it was unique in President Nixon's impeachment. It was unique in President Clinton's impeachment. And here again, matters have evolved. The president will get his due if there are articles of impeachment. And that's what I find passing strange, that you all seem to accelerate it to the point of there are articles of impeachment where clearly the resolution reflects that he will have full responsibilities that he can discharge in that particular undertaking.
I would just remind the gentleman, and I think this is an important point, we are setting precedent for the future. Be
And
careful with what you do.
that's a good thing.
Mr. Woodall?
I knew I would value my friend from Florida speaking before me, because he does always speak from years of experience. These do reference the ongoing investigations that are going on in each of these committees. My friend on the Financial Services Committee spoke eloquently of the work that's already going on. There are no new authorities provided in this resolution to any of those committees. No new authorities provided to any of those committees in this resolution. Oversight is our constitutional right. We do not need an HRES to give it to us. Historically, when we begin to talk about impeachment inquiries, the investigations have happened, and the Judiciary Committee begins that process. The one who's putting the cart before the horse is the one who still thinks 8 committees need to be investigating this because they haven't dug up whatever the smoking gun is they were looking for yet. This resolution provides opportunities for the president and his counsel to be involved, as always happens in an inquiry. But it does that in one committee and one committee only. If this is that stage of the process where one committee and one committee only is investigating the collective work product of all of the other committees, then my amendment should have been accepted, and we should have this process going on in the Judiciary Committee. If all of these other committees are involved in a way that needs to guarantee fairness to the process, and you'd like to provide the president and his counsel a role in that, we would in fact need a resolution to provide the Article 2 folks an opportunity to participate. But you are not choosing to do that. And what's passing strange is that this purports to be the official beginning of the impeachment inquiry, which purports to affirm the continuing existing impeachment authority, which purports to provide fairness and opportunity to the president, but not in any of these first 7 committees that are working now, but if and when it ever gets to the Judiciary Committee, we might give you a shot at the apple. Then that's the
yield
I'd be happy to yield my.
Yeah, I just am curious. You are mindful that during all of these proceedings that have taken place, as well as those that are proposed under this resolution, that the minority party is present and accounted for if they choose through counsel and their own inquiries. 1/3 of all of the respective committees identified here have members of the Republican Party on them. You are aware of that?
I am aware that tells half the story. As you just heard from our friend from Arizona, you don't have to look past the last 24 hours to find opportunities that those same Republican members that you're talking about, who absolutely have a seat at the table, had the audacity to use their voice at that table to ask a question, only to be shut down by the chairman of that committee.
And let me say something about that. That shouldn't even be being discussed here. And let me send a word out to all of the members of the Intelligence Committee, as well as those committees that are on these respective committees. Matters ongoing before those committees are to be left in secret. Loose lips sink ships. They have a sign down there that tells you that. And we've had absolutely too much talk and too little action here. All of the process that I hear you all arguing about doesn't address the possibility that this president has committed high crimes and misdemeanors.
And I just want to correct the record. You said that this resolution purports to begin the impeachment inquiry. The impeachment inquiry has already begun.
I apologize.
That's okay. I just wanted
thought
to set
that
the record straight.
well, impeachment is the power of the House.
Right.
And this is the House resolution on which we're voting. I understand that various partisan chairmen are doing
Right, yeah.
the work of partisanship, but this is the House speaking on impeachment.
And, Ms. Lesko she wants to speak.
Thank you, Mr. Chairman. I just wanted to say something about what Mr. Hastings just said. And I agree with you. Everything should be kept secret. Unfortunately, I keep reading what's going on, selectively leaked, I assume, by the Democrat chairman or the Democratic staff of the Intel Committee, because I don't even know that the leak is the right word. It's just given to the New York Times. I'm reading about stuff that I, as a member of Judiciary Committee, can't even hear the testimony of these people. Yet it's just given to apparently to the New York Times. I mean, that's not right either.
The vote is on the Woodall Amendment.
No, it's a Burgess amendment.
I'm sorry, the Burgess Amendment.
That may make people more inclined to vote favorably.
Yeah, all those in favor of the Burgess Amendment, say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it.
I'll ask for a roll call vote.
Clerk will call the roll.
Mr. Hastings? Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall?
Aye.
Mr. Woodall, aye. Mr. Burgess?
Aye.
Mr. Burgess, aye. Mrs. Lesko?
Aye.
Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments.
Yes, I have an amendment.
Mr. Burgess.
I have an amendment to desk.
Clerk will read the amendment.
Amendment number 3 to House Resolution 660, offered by Mr. Burgess. Page 6, line 2, insert A before the chair. Page 6, after line 7.
I ask unanimous consent that the amendment be considered.
Without objection. Mr.
So
Burgess.
this amendment, again, requires the Committee on Financial Services, the Committee on Ways and Means, to produce documents detailing the nature and scope of their investigations and make them available to all members who ultimately will be required to render a decision on this matter. Again, it is unclear why these two committees are included in the list of committees directed to continue ongoing impeachment investigations. The only reason for including these committees is an attempt to uncover an impeachable offense in President Trump's tax returns. These committees need to define for the House of Representatives and for the American people the nature and scope of their investigations as they relate to the impeachment inquiry, an inquiry which was officially declared to investigate a whistleblower complaint regarding foreign assistance.
You heard the Burgess. Any comments or? Hearing none, the vote is on the Burgess Amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
And I'll ask for a roll call.
Clerk will call the roll.
Mr. Hastings?
No.
Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall?
Aye.
Mr. Woodall, aye. Mr. Burgess?
Aye.
Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman,
Mr. Woodall.
I have an amendment to this.
Clerk will report the amendment.
Amendment number 4 to House Resolution 660, offered by Mr. Woodall. Page 5, insert after line 25 the following. The Chair of the Committee on Rules shall submit additional procedures for proceedings pursuant to this resolution for printing in the congressional record, including such procedures as to allow for the participation of the President and his counsel. At the end of the following, Section 5, Impeachment Inquiry Procedures and Other Committees. For the purpose of continuing the investigation described in the first section of this resolution, the Committee on Foreign Affairs and the Committee on Oversight and Reform are authorized to conduct proceedings pursuant to procedures as the Chair of the Committee on Rules shall submit for printing in the congressional record, including such procedures as to allow for the participation of the president and his council.
There.
Mr. Woodall.
Thank you, Mr. Chairman. I apologize for using the committee's time. I wanted the clerk to read the entire amendment because while I vociferously object to setting the new precedent of using all of these committees in this circumstance, I acknowledge I lost that amendment. And so what this does is saying, fine, if you want to do not just a bifurcated or trifurcated, I don't know what a seven-way split is, thank you, Doctor, that in the same way that the majority is authorizing the Rules Committee to create a list of procedures by which the president has an opportunity and his council to participate in the in the activities of the Judiciary Committee, to also ask the chairman, in his wisdom, to create that same set of procedures so that the president and his council can participate only in activities as it relates to the authorized scope of the impeachment investigation, participate in those other committees as well. That sounds like such an obvious yes to a bipartisan vote. I knew you wouldn't believe me if I described it on my own. So I wanted the clerk to read it word for word. It simply says, exactly as we've asked the chairman of the Rules Committee in his wisdom to create an opportunity for fair play and due process in the Judiciary Committee, we will also ask the chairman of the Rules Committee to create an opportunity for fair play and due process in the other committees. And I thank the chairman.
I thank the gentleman. Any discussion or Mr. Perlmutter?
Yeah, so I'm going to read these too. So Article 1, Section 2.5 of the Constitution of the United
States of America, the House of Representatives shall choose their Speaker and other officers and shall have the sole power of impeachment. Then 3.7, Article 1, Section 3.7, judgment in cases of impeachment shall, 3.6, the Senate shall have the sole power to try all impeachment. So let's just go back to basics, to Civics 101. The impeachment is the complaint against the president. It isn't the trial. The trial is in the Senate, in which case the Senate creates its own rules by which it will determine whether the president is getting due process or not getting due process. But the complaint, the impeachment, the indictment against the president is what we do. And so to the degree you want to have more due process, the due process is part of the trial. And so, listening to everybody talk about, well, it's just not fair. What has been happening, because this is something like a grand jury coming up with a complaint or an indictment, but it allows for Republicans to ask questions and Democrats to ask questions in the process of developing a complaint in an area where it seems like national security is really at stake, and issues of the intelligence community is at stake. And so to the degree that my friends, Mr. Woodall, Ms. Lesko, Dr. Burgess, are complaining that there's no due process, that it's not fair, Republicans are getting to ask questions, Democrats are getting to ask questions, it's in an arena involving the intelligence community, there will be an open process in the Judiciary Committee, and there will be a trial if impeachment is authorized in the Senate. So I would also suggest to my friends that they be taking up some of their questions about due process with the Senate, where the trial actually takes place.
Would my friend yield?
Sure.
As is so often true, I don't disagree with a thing that my friend said. Though when this House considered its role in impeachment, in the Nixon impeachment, we decided collectively that fairness and due process required that the president and his council have a role in that. When we did the same.
And I thank the gentleman, and I reclaim my time, but between Archibald Cox and Leon Jaworski,
Right.
the special prosecutors that had been appointed to, in effect, do the grand jury phase of the investigation, that was separate and apart, and then the information, including everything but the missing 19 minutes, was delivered to the Congress. for discussion and development and determination whether impeachment was appropriate. And then articles of impeachment were then brought to the floor of the House, where some were voted yes and some were voted no.
Would my friend yield further?
Of course.
I understand the history to be exactly as my friend from Colorado described it. That's just not what we're purporting to do here today. If the Ways and Means Committee wants to go and gather information to then turn over to the Judiciary Committee to pursue an impeachment inquiry, they don't need this committee and this resolution to do that. They're out there doing their oversight work as the Constitution requires every single day of the week. This resolution purports to do something new, that to begin that process. As I read the resolution, all of these other committees can do their work. The primary ones can do that work in almost total secrecy. It can then be turned over to the Judiciary Committee, rubber stamped at the end. The process you described
Okay,
had the
so
full-throated discussion.
Let me
in the
reclaim
public
my
sphere.
time.
I
Let me
thank my
reclaim
friend.
my time. So I guess you're saying, well, you don't really need this to go do what you're doing in the financial services and the Ways and Means, but certainly I think this gives some responsibility to our committee, the Rules Committee, to say, as you're going about these investigations, because they are ongoing at this time too, we want you to turn those pieces of information over. And so I think, in effect, this would be something you would want in addition to what their oversight responsibilities are today.
Would the gentleman yield?
Sure.
Just to elaborate that final point, I have to admit I'm a little bit baffled because from our colleagues across the aisle for the last several weeks, all we've heard is you're in a process, but you haven't had a vote. Well, now we're going to have a vote. Then we hear, well, we want open hearings. This is a process for open hearings. That's precisely what we're doing. And now we're getting the objection, you could have done this without a vote. Well, yes, we were doing without a vote. You guys wanted a vote. We're going to have a vote. We're going to make it perfectly clear what's going on here. And it's going to be open hearings. So it seems like what we're getting more and more of is complaints about process. And they do seem to be flipping back and forth on different sides. And it almost seems as if we don't want to deal with the substance of the president's conduct. And I can understand that. But we do have an Article I branch responsibility, all of us, to pursue high crimes and misdemeanors, offenses against America.
Wouldn't my friend from Maryland yield?
But it's not my time, but I yield back.
All right. Mr. Cole.
Okay, I just have a question from my friend from Georgia, maybe a couple questions. Number one, why do you think we have the president's attorneys with certain rights inside the Judiciary Committee?
Because my constituents want the work product to be not a partisan work
No,
product. They want it to be
make the
open and
process
honest.
appear fair.
That's exactly what they want.
If that's fair, why is it, why are the other committees not giving the president have the same right, since they're developing the very basis for impeachment? And to my friend's point, a debate over process, that's what the Rules Committee is. That's what this is. This is a resolution about process.
Right.
So we are going to debate process. That's your choice, because you're setting up a process. So, please, no more complaints about debating about process when that's what the resolution is. It sets forward a process. But to my friend, again, you think it's going to strike your constituents as being unfair that in multiple committees, pursuing the president will not have an attorney, will not have any sorts of rights? Well, in many cases, they can be held in secret.
I am told that this is the official House position on impeachment, and we are offering the president a role in 1 out of 6 committees mentioned here.
Thank you.
Well, and let me just say, finally, before we call the question, and I've explained this several times, but it's not getting through, I don't think. But what's unique about this particular situation is we don't have a Ken Starr. We don't have a special prosecutor building the case, right? These committees are building the case. It will be turned over to the Judiciary Committee. The president has been afforded all kinds of rights before the Judiciary Committee. This is a fair process, and it is an open and transparent process. This, we're at the next stage here. The gathering of the evidence is coming to a close. It is now time to present the evidence to the Judiciary Committee and to the American people, and here is the roadmap. And we're going to explain it. We're having an open hearing here today. and we're explaining how we're going to do this, and I think it's a good process. With that, the question is on the Woodall. Ms. Lesko would like to add something.
Thank you, Mr. Chair. You know, I support this amendment. I just disagree with you. This is not, what you have set forth here is not an open and fair process, because you're giving some of the rights that were afforded to Nixon and Clinton under both Republican and Democrat leadership in just the Judiciary Committee. But there's a huge difference. Under those impeachment hearings, it was all done in the Judiciary Committee hearing, and you were able to have, the president was able to be there.
And he'll be able to come to the Judiciary Committee if he wants.
Yes, but there was no closed-door meetings. I mean, you're comparing Representative Adam Schiff to an independent counsel, Ken Starr. That's just, it's not the same. I mean, Ken Starr, I don't think, went out and for 2 years claimed he had proof that President Trump colluded with Russia, and then that turned out to be false in the Mueller report. And I don't think Ken Starr went on TV and said, no, our office never had any previous conversation with the whistleblower complaint, and that turned out to be untrue. I mean, you're comparing apples and oranges, and I just don't think that's fair. And in addition, in these closed-door hearings, Republican members that are supposed to be allowed in those committees, they're on those committees, they've told me that if, let's say they have to step out for a minute to go do other business, that they can't even get the transcripts. And that in order to do it, they have to go in front of a Democrat member, and like they're being babysat by the Democrat member. This is just not fair.
Well, we're going to have to agree to disagree, but I want to say for the record, Trey Gowdy, a Republican, said of the Select Committee on Benghazi's interviews, quote, "The private ones always produce the better results," end quote. Greg Nunziata, former Republican Senate Judiciary Committee counsel, said, quote, "People should know that closed-door depositions and interviews by bipartisan staff, which is what is happening now, are absolutely routine in congressional investigations. This is normal. It helps Congress put together a factual record." He went on to add, "Republicans are," and I quote, "wrong to suggest there is something nefarious or illegitimate about what is being done here. It is normal operating procedure, and a record is being built," end quote. I mean, even Trey Gowdy said the same thing during the Benghazi investigation about prematurely releasing transcripts. Quote, "Releasing transcripts can impact the recollections of other witnesses, jeopardize the efficacy of the investigation, alert witnesses to lines of inquiry best not made public, and publicize personal information." Look, at the bottom, I think we disagree. The bottom line is we want to get to the truth. And I think what we're seeing here are attempts to try to find ways to be able to delay us getting to the truth, or actually blocking us from getting to the truth. And I think that there's just a fundamental difference here. You know, we are genuinely horrified by the lack of cooperation from this White House on any of these investigations. We are deeply disturbed by what we are hearing each and every day coming out of the various committees. And so we believe that we need to get a process in place to get the evidence out there, and people can decide. I mean, this is not this is not a hearing on whether the president should be impeached. That will be determined at some other point. This is a hearing on trying to get a process in place that I think is transparent, that has dignity, that respects this institution, and that is what we're doing.
Mr. Chairman?
Mr. Torres. Torres. No? Okay. Mr. Burgess?
Mr. Chairman, if you just yield for a question, I don't recall if my good friend Mr. Gowdy ever prevented the Democratic members from questioning the witnesses.
And I don't think anybody is preventing Republican members who are on the committees of questioning witnesses. I don't know. I mean, that just, I don't know what you're talking about.
But if they instruct the witness not to answer, that's preventing.
Yeah.
Oh, yeah, but, all right. The question is on the Burgess Amendment. What else? Mr. On the Woodall Amendment, all those in favor say aye. Aye. Opposed, no. No. Opinion chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings? No. Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? Mr. Raskin? No. Ms. Scanlon? Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? No. Ms. Shalala? No. Mr. DeSaulnier? Mr. DeSaulnier? No. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments. Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment at the desk designated Cole number 5.
Clerk will report the amendment.
Amendment number 5 to House Resolution 660, offered by Mr. Cole. Page 3, beginning on line 5, strike only and all that follows through periods of questioning. On line 9.
I'd ask we
and-
dispense with the reading.
Without objection.
Thank you very much,
Gentleman's
Mr. Chairman. Mr. Chairman, it's a significant deviation from historical precedent, and frankly, I think silly, to tell a member of Congress that they can yield to an unelected staff member, but they can't yield to another member on the very committee they're on. I mean, that's just common practice around here. So my amendment simply restores the right of members to yield their time to any member of their choosing. Absolutely no reason to prohibit the chair and ranking member of the Intelligence Committee from yielding time to anyone but an employee. So, I mean, why you would not let them yield to another member of Congress on the same committee is beyond me. So I would like to restore that right to all the members of the Intelligence Committee. Micromanaging member time, is just, I think, well beyond the scope of what we ought to be doing in this resolution.
I heard the gentleman's amendment. Any discussion? Mr. Woodall.
Mr. Chairman, again, we didn't have the benefit of having a hearing on the resolution, so I don't know why that is in here. It is such a dramatic departure. You've had my Democratic friends yielding me time here on this very contentious issue. It's not just normal to yield time to your colleagues on your side of the aisle. It's a common practice to yield time across the aisle. Surely something as important as an impeachment, the additional 37 seconds one might save by not allowing me to yield that time to a colleague is counterbalanced by a desire for full-throated debate.
Any other?
But my question was for folks who were involved in the drafting of this resolution. I most decidedly was not.
Well,
Why this was.
I would say that why it's important is that members obviously all will be recognized. All members will be able to ask questions. What this creates is the ability for professional staff to be able to question a witness for a period of time to actually be able to do it effectively. And that's the
If I may,
point.
Mr. Chairman, it's my amendment. There's nothing in my amendment that would prohibit doing exactly what you just said. I mean, you certainly could still yield your time to the staff, but we're specifically prohibiting members from yielding time to other members. And I don't know why we would do that. We again, as my friend said, we do that back and forth. We're doing that right now.
Well, like in this committee, if members agree by unanimous consent, they can do whatever they want in these committees.
Well, can you tell us the purpose why you wouldn't allow another member?
I mean, because the purpose of this was to give professional staff the ability to cross-examine witnesses
Nothing
in a
in
way
my-
that makes these hearings less of a circus and more focused on the facts.
Well, again, nothing in my amendment would prohibit.
Well, and there's nothing that will prevent anybody in any committee asking unanimous consent to be able to yield. We could agree to disagree on this. Ms. Torres?
Mr. Chairman, we've had a lot of back and forth, and we had Republican members in the depositions that a myth is that they've been excluded from the process. And, I have a lot of respect, for my colleagues here. But the bottom line is that Republicans have been allowed to ask questions. There has been nothing in secret that has been going on in these classified briefings where Republicans have been excluded. If I may finish, what is secret is when you take a transcript of a telephone call and you're so worried about the content and the words that came out of the person's mouth that you have to hide it in a secret file. That's offensive. Another myth that the minority has no rights under this democratic process, we will continue to give the minority the same rights to question witnesses as the majority. That is the precedent, and it was true yesterday, and it is true today. It has been true every step of the way, and it will continue to be in this process. Now, I understand that there is a lot of pent-up anger from some Republican members who feel that they have been shut out of participating in these classified briefings. Well, every member of Congress can't serve on this committee. Folks, based on trust and responsibility, have been assigned to serve on this highly classified committee. And folks like me that are not on this committee have been granted this great opportunity to work on other things. And we have worked on many other things because the agenda of the people continues to move forward. So if you're angry that your leader did not allow you to sit on this committee so that you can participate in a process that you want to make a political process, I'm sorry for you. There is nothing in this resolution that is going to make you feel better. And if you would like fair about that process, then I want to invite you to the LA County Fair, where everything is fair. I yield back.
Thank you. Mr. Cole.
Well, again, I have enormous respect for my good friend. We work together on a lot of issues, but none of that has anything to do with this amendment. The amendment just simply says, can a member yield his time to another member on a committee? Why are we
And the
prohibiting?
answer is yes, if they get unanimous consent to do so.
We don't need unanimous consent to yield on any committee that I've ever sat on. We don't do it here.
I mean, the gravity of what what we're talking about here today is unbelievable. I mean, this is a very serious matter. We can spend a lot of time on things like this, but there's, if there's unanimous consent in the committee, members could do whatever they want to do. And and so I don't really have anything else to say, but Mr. Woodall would like to say something.
Again, I've been on the Rules Committee. I've not been on a lot of authorizing committees. I thought we specifically created the 90 minutes in this resolution because it is not easy for committees just to up and create extra time like that. And what this language does, and it again, I've not seen it before, it allows me to yield time to my friend Don Sisson as a professional staff member, but won't allow me to yield time to an elected member of Congress.
Well, you can if you get unanimous consent, but let me just say this for the record, as Chair of the Rules Committee with no time limits here, giving members more time is a little bit overrated.
This isn't
So,
more time.
I'm just telling you.
This isn't more time. It's the statutory amount of time. And I would.
Yeah, they will get their normal time. I mean, they're not saying they're not going to get any time. Anyway, if you want to continue this, we can. If not, we'll call the vote question on the Cole Amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will call the, report the total.
4 yeas, 9 nays.
Amendment does not agree to. Ms. Lesko.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will read the Lesko amendment.
And I, with unanimous consent, dispense of the reading.
Without objection.
Mr. Chair, as currently written, this resolution says that the minority witness request will be reviewed. However, there is no guarantee minority rights will be honored and Republican witness requests will be granted. Therefore, my amendment simply would allow the minority to call an equal amount of witnesses as the majority. This will ensure this process is handled in a fair, just fashion.
We heard the Lesko amendment. Is there discussion? Mr. Raskin.
Mr. Chairman, I rise in strong opposition to this amendment. And it gives us the opportunity to clear up, I think, a misperception that somehow the minority in the Clinton and Nixon cases had unilateral subpoena power. They did not. It was always possible for the majority in either of those cases to prevent a witness from being called or a subpoena to be issued. We're actually offering precisely the same powers to the minority that have been extended in prior impeachments. And in fact, in some ways, the president gets more powers under our resolution than the president had in prior impeachments. In our case, the president will receive a copy of the Statement of Information and related documents and evidence. That took place in Nixon. Actually, it didn't take place in Clinton. Clinton did not have the benefit of a presentation of evidence because the majority at that point essentially just took the Ken Starr report and turned that into its evidence in the case. He didn't have the opportunity to cross-examine any of the witnesses against him. In the Nixon case, the president and his counsel were invited to attend the presentation of evidence, and we do that as well. In the Nixon case, the president's counsel could not ask questions at the presentation of evidence, but in our case, we are allowing the president's counsel to ask questions at the presentation of evidence. The president's counsel in the Nixon case could respond to the presentation of evidence, and again here, and right down the line, we have essentially followed what's taken place before, except, as mentioned, the president gets more powers here. But the suggestion that the minority had a unilateral subpoena power and could issue subpoenas without the consent of a majority of the committee is just wrong. The way it was set up before was that the chair and the ranking member could act together to issue subpoenas. If they disagreed, one could go forward unless a majority of the committee opposed it. And that always gave the majority the power to block a minority subpoena. So I would oppose this resolution, which would endow the minority with powers that it never had before in a prior impeachment. I yield back.
Ms. Lesko.
Thank you, Mr. Chair. And yeah, I think we need to investigate this further because I actually have differing information. And it says that, please note that under the previous impeachment rules, the ranking member could unilaterally issue a subpoena so long as the chair did not object.
Would the lady yield?
Under Clinton and Nixon, there was an option for chair to not join. So I think there's a nuanced difference that I need to
I can read to you the
investigate
actual
more.
language if you're interested. I don't know where you're reading from. Where is that? Where are you reading from?
I'm reading from an email I got from staff.
Okay. But I have the actual language, which I'm happy to read, where we can provide it to you, you know.
Why don't we insert it in the record with unanimous consent?
Okay, I'd love to submit it to the record, Mr. Chair.
All right, no further discussion?
No.
Oh, Mr. Morelli.
If I can, Mr. Chair, first of all, I want to thank you for bringing forward the resolution in chief that ensures certainty and transparency in the next phase of the impeachment inquiry into the president and urge defeat of the amendment. I'm deeply troubled, as I think we all are, that this process has become necessary at all and that the House has had to investigate alarming allegations of misconduct. However, I am grateful they were ready to set forward the next steps of the impeachment inquiry, one in which all parties are guaranteed the ability to participate in fact-finding, in which the public will have the ability to access and to assess for themselves the evidence. And I know my constituents back in Rochester, New York, are grateful that this resolution will allow the House Intelligence Committee to release public transcripts of the depositions that have already taken place while maintaining caution to protect classified and sensitive information. The public phase of this inquiry will allow precedent on the gathering of information, witnesses, and documents, as well as the advancement of articles of impeachment, should that be necessary through the Judiciary Committee. This has not been, and I appreciate the eloquence of my friend, Mr. Raskin, and I want to associate myself with his remarks, but this has not been and will not be controlled by the Democratic majority in the House. Republican members and leadership have the opportunity to question witnesses, seek evidence, and refute any testimony presented during these proceedings. And the process outlined today will continue to expand, as Mr. Raskin has indicated, the protections for the president seen under the Nixon and Clinton inquiries, including express rules in the resolution allowing the President's counsel to ask questions and offer a concluding presentation, which I don't believe was in the previous investigations. These have not been guaranteed, and and I'm not sure I agree, Mr. Raskin, I'd love to know where the information comes from Ms. Lesko has presented. My understanding is they have not been guaranteed in past impeachment proceedings, and I hope that both sides can see that we are committed to a fair and open process with the goals of discovering the truth and protecting the American public. This is a solemn occasion.
Thank you.
And it is our obligation nonetheless, and I urge my colleagues to join me in defeating the amendment and supporting the resolution so we can uphold our oath to the Constitution and provide a transparent process on behalf of the American public.
Thank you. The vote now will be on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. The clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. I want to inform the committee that there's a series of 10 votes that have been called on the House floor. So members are asked to vote and return at the start of the last vote. So without objection, the committee stands at recess until the beginning of the last vote.
Microphone check, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Say microphone check.
The committee will come to order. Are there any further amendments to H-Res 660? Mr. Cole.
Thank you, Mr. Chairman. I have an amendment at the desk designated as Cole number 7.
Clerk will report the amendment.
Amendment to House Resolution 660, offered by Mr. Cole.
Chairman, I'd ask we
Page 3.
dispense with the reading.
Without objection, Mr. Cole is recognized.
Thank you very much. This is actually a very simple amendment, Mr. Chairman. I just think a matter of courtesy. My amendment strikes the unnecessary and onerous requirement that the ranking member submit a written justification to hear witness testimony relevant to the investigation. In the interest of fairness and due process, this written justification requirement, in my view, ought to be removed. Appears to serve little purpose other than discourage participation of the ranking member, and it just adds needless bureaucracy and process that I don't think is necessary, so I would ask that it be removed.
I heard the gentleman's amendment. Is there any discussion on the amendment? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Ask the roll call.
Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier? No. Mr. DeSaulnier, no. Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Can I ask how Ms. Scanlon is?
Ms. Scanlon is not recorded.
Ms. Torres.
Ms. Scanlon, no.
And how is Ms. Torres recorded?
Mrs. Torres is not recorded. Mrs. Torres, no.
And how is Mr. Raskin? Oh, he's already, okay. Clerk will report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Mr. Cole.
Thank you very much, Mr. Chairman. I anticipated that might have been the outcome. So I have another amendment at the desk designated Cole number 8.
The clerk will report the amendment.
Amendment number 8 to House Resolution 660, offered by Mr. Cole. Page 5,
Would ask that
insert.
the reading be dispensed with, Mr.
The
Chairman.
reading is suspended without objection. Mr. Cole.
Thank you very much, Mr. Chairman. Under the theory that what's sauce for the goose is sauce for the gander, this amendment requires that each witness called to testify at a hearing of the Permanent Select Committee on Intelligence under resolution, the chair submit the ranking member a detailed written justification of the relevance of the testimony of the witnesses of the investigation. All we're asking is exactly the same thing for the minority. We would be happy either way, either get rid of this, but to require it from the ranking member and not require it from the chairman just seems, again, both unfair, burdensome, almost a calculated slight. So just they ought to be operating under the same set of rules on something like this.
You've heard the amendment for Mr. Cole. Is there any discussion, Mr. Woodall?
Mr. Chairman, candidly, I thought that Mr. Cole's first amendment was going to pass because there is a degree of collegiality in every committee. Sometimes folks call witnesses for partisan purposes. Some folks call witnesses to shed more light than heat, but we all understand that. And so if, as has been stated by each and every member of the minority here today, that we're giving fair opportunity to minority members to participate in the committee process, it is beyond me why it is that one needs the written justification to begin with. But if folks have deemed that to be an important part of the process, important for transparency, however you all have described it, why in the world wouldn't we also want to add that to the chair? Again, if folks want to stack the deck, that's a legitimate decision to make. I would oppose it. I don't think it's right for America, but folks could do it if they wanted to. If what folks want is a fair and open process, why would different rules that none of us are accustomed to complying with, why would new rules apply to minority requests for participation that don't apply to the majority? And again, if we had had any hearings on this, which we have not, I would have asked that to someone who has drafted this. I did not participate in the drafting, and I would welcome any of my learned friends to tell me what the value of this is, because I do believe, sincerely, I believe that my friends in the majority are trying to do what they think is best for the American people. I don't understand why advantaging one party over the other when transparency is the goal is.
I hardly, thank you, and I hardly think this is a burden to explain why you want to call certain witnesses, and especially in light of the fact, since you raised the issue, I think, one of the concerns has been that a number of members on your side of the aisle have gone out of their way to try to detract from the central investigation. I mean, there are allegations the President of the United States requested a foreign leader and his government to initiate investigations to benefit his own political interest. And it seems like nobody on your side wants to talk about that, and instead, wants to talk about other things, Hillary's emails, or you name it. I mean, anything but this. And so this is, I think, an attempt to make sure that we are focused on the matter at hand. And so I don't think it's an unreasonable or burdensome requirement, but if the gentleman does, then he can offer, he can support the Cole Amendment, and we can.
To be fair, Mr. Chairman, I agree with everything you just said. The Cole Amendment that's before us says this is not a burdensome requirement, that it's absolutely something that is reasonable to request and folks should have it. And so let's make that demand of the majority members of the committee.
Well, I would say,
Mr. Cole agrees with what you're saying.
Well, what I would suggest is that the ranking member of whatever committees you want to talk about, work it out with the chair of the relevant committee. So I just don't. I mean, again, the subject at hand is so horrific and heavy that I understand that you think this is important, but in the scheme of things, I think it is, not a big deal. And I think that we ought to be focused on getting to the truth because there's some very disturbing allegations out there.
Reclaiming my time, I think you're exactly right. The allegations are disturbing. The topic is serious. And for us to be meeting with that precise goal in mind and to have these amendments dismissed as somehow being inappropriate, I don't even have someone I can ask with the legal mind and the decades of experience to say, why did we do this? We don't ever do this. What purpose does this achieve? There may be a perfectly legitimate one, but no one can explain it to me, a sitting member of this committee. So my ranking member says, listen, I don't think this is a good idea, let's take it out. The majority unanimously says, no, it's a great idea, let's keep it in. So the ranking member, maintaining my time, so the ranking member says, okay, if this is a great idea, if the American people are going to benefit from it, let's apply it across the board so that Republicans and Democrats are treated the same in this process. That's the amendment that's before us today. If it's a silly amendment, if it's a waste of time, so too was the underlying provision that included it to begin with. If it's not a silly amendment, if it's not a waste of time, then I ask for my colleagues' consideration of it, to present in a process committee a bill that does nothing but process, does it for the very first time in many instances, has never been the subject to a hearing, that burdens an intelligence committee that should be focused on anything but an impeachment proceeding, those things that should be in the Judiciary Committee. Goodness knows our Intelligence Committee, as we all saw yet again in our briefing today, has lots of other work to do. If there is a reason to stack the deck or to level the deck, I'm open to hearing it. But no one has shared it with me.
We're interested in getting to the truth. And
is that,
Mr. Cole, is that-
maintaining my time, Mr. Chairman, and I'd be happy to yield to the chairman, is getting to the truth thwarted by asking
No.
the same of the majority that you're asking the
No,
minority?
I think getting to, I think.
No
I think
is the answer.
No,
I accept the gentleman's answer.
I think what the purpose here is to focus in on making sure the investigation moves forward and not on a bunch of sideshows that, quite frankly, there are some on your side of the aisle who are interested in pursuing. But anyway,
Yeah, I'd be happy to yield.
I'm happy to.
I'd be happy to yield.
Mr. Cole.
I'd be
Yeah,
happy to
thank you
yield
very
back.
much, Mr. Chairman. Just want to make number one, we're in a process debate. That's what this resolution is. So, I don't dismiss the importance of the underlying subject at all. And I know I would hope you know, and I believe you do, that I don't. But this is what we're debating tonight. And so we're going to end up in process arguments. But the second point, it's just this is just a matter of simple fairness, the same requirement. Why in the world, if it's important for the minority to do it, the majority should do it, or if it's not important for the majority, it shouldn't become a burden on the minority. I just think if you want an equal process, you want something that's fair so that it outcomes, this is, to me, somewhat similar to not letting members yield to other members. I mean, I think we're getting down to managing members, ranking members, regular members on the committee in ways that are unfair, intrusive, and border on micromanagement. So I think pulling some of these things out would actually strengthen the resolution. So with that, yield back, and thank you for the additional.
Mr. Murley.
Yeah, I would just add, it seems to me it is a level of micromanagement in the first place to ask for this amendment to be included. And secondly, can't imagine there's much precedent in the House of Representatives on oversight hearings and hearings of this nature that would require the chair of a committee to file a detailed written report asking why information or witnesses ought to appear before the committee. I think this is an effort to derail this and just add additional hoops for people to get through to get to the truth, and that's why I think. I'm happy to yield, Mr. Cole.
I mean, I don't know of any committee that goes through this process. I don't know of anyone. Look, I've been a chairman of a subcommittee on appropriations. I never required something from my ranking member to bring a witness in that then I didn't do myself. That's the problem here, is just the double standard. By all means, if you think this is important, I don't particularly. Obviously, my first amendment was let's just get rid of it. If you think it's important, fine, but just make it fair. Apply it to every witness that comes before the committee, whoever calls them.
Well, but as I read the process, the ranking member will have every right to request the subpoenas and information from witnesses, and only and certainly the chair can decline it, but there's an appeals process, which is to ask the committee to vote. So I would urge defeat of the amendment.
Fair enough. Just require the same thing of everybody that's calling witnesses. Why single out one side?
Vote is now on the Cole amendment. All those in favor say aye. Aye. Opposed, no. No. Can the chair of the noes have it? Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Members not agreed to. Further amendments. Mr. Cole, Mr. Woodall.
Thank you, Mr. Chairman. I have an amendment at the desk, designated number 9.
Clerk will read the amendment.
Amendment number 9 to House Resolution 660, offered by Mr. Woodall. Page 6, strike line 24 and all that follows through line 24 on page 7 and insert the following. The ranking minority member of the Committee on the Judiciary is authorized to request witness testimony relevant to the investigation described in the first section of this resolution from a number of witnesses that is equal to the number of witnesses requested by the chair of the Committee on the Judiciary. Subject to paragraph 3, the ranking minority member is authorized to require, as deemed necessary to the investigation, by subpoena or otherwise, the attendance and testimony of any person, including at a taking of a deposition, and the production of books, records, correspondence, memoranda, papers, and documents, and by interrogatory, the furnishing of information. The ranking minority member may require the attendance and testimony for purposes of the investigation.
Mr. Chairman, I'd ask unanimous consent to dispense with the reading.
Without objection.
Yeah, thank you, Mr. Chairman. The language that has been the subject of much discussion, how folks are subpoenaed and whether or not the minority has an opportunity has been the topic of great discussion. What my amendment would do, and it only to the Judiciary Committee section, where we all believe that the fact-finding is going to ultimately happen, would say if, as currently drafted, the chair has complete ability to say yes or no, and then have his majority members support him on that, to not allow any subpoenas at all from the minority. What this would say, because truth is the goal, and because by the time it gets to the Judiciary Committee, we are in the final stages of this process, to say there is going to be a requirement that if the majority is involved in calling fact-finding witnesses before the committee, the minority will in fact have that same right. The minority may not exercise it. I would expect the majority to call countless more witnesses than the minority would call. But it does set into this resolution the understanding that this isn't a puppet process. This isn't rigged so that as all committees are, stacked with majority members, able to deny all minority requests. It stipulates that in something this serious, if we are going to have this, if we are going to have witnesses subpoenaed and appearing on behalf of the majority, we will in fact definitively allow them to also appear on behalf of the minority. I yield back.
Yeah, and I just say for the record, the impeachment inquiry into President Donald Trump is operating under the same subpoena rules championed by Republican leaders in previous Congresses, including former Representative Trey Gowdy and Mike Pompeo. Neither of the two previous impeachment resolutions for Richard Nixon and Bill Clinton allowed minority members to issue subpoenas unilaterally. Instead, they allowed the ranking member to propose subpoenas, but those subpoenas could be issued only if the chair agreed or the full committee voted to approve them. So we are remaining consistent with procedures that my friends embraced and that were utilized under the two previous impeachment inquiries under Clinton and Nixon.
If I could be recognized, Mr. Chairman.
Yeah.
I recognize the spirit in which you say those words. Those are factually inaccurate. We would have an opportunity to discuss them if we had fact-finding witnesses and if we'd had hearings.
I will say, I will respond to that, they're not factually inaccurate.
Well,
okay?
if the gentleman would hear me out, I suspect we could find agreement. So often we find ourselves in this chamber arguing with one another, only to find out we actually agree 100%. Let me stipulate that I'm absolutely asking for something that was not given to Democrats in the Clinton inquiry. I was here during the Clinton inquiry. I'm absolutely asking for something that was not granted to the minority during that time. I stipulate that's true. I'm asking for it anyway because I think it's important. But my recollection from that time is that the process was very similar to what you have crafted here, but was not the same. During that time, whether it was the chair or the ranking member, if one of those disagreed with issuing a subpoena, the entire committee voted on whether or not to move forward. That is not the rule that you have created here.
No.
Once again, in what seems to be very, very petty partisanship, it makes no functional difference because of the way the committee operates.
Well,
you say if the ranking member asks for a subpoena and that's denied, the full committee will vote. But if the chairman asks for a subpoena and the ranking member doesn't like it, that's just too bad. The committee won't vote to validate the chairman's position. That is factually different, and I would appreciate the gentleman's recognition that.
And my understanding is that we are operating under the rules that Republicans put into place.
In 1998,
where chairman can now unilaterally issue subpoenas. That's something
you're absolutely right about that.
So we're following your lead on that.
Again, Mr. Chairman,
So,
the details matter.
Happy to.
The details matter here, and what and I'd be happy to yield with my friend from Colorado if he can provide clarity.
I'm going to just have my own time.
Fair enough.
Okay.
It is true both then and now that chairs and ranking members can issue subpoenas unilaterally. It was true then, it's true now. It requires the approval of one another, the absence of an objection. But clearly, the provisions allow that you don't have to have both signatures on the subpoena, and we do that out of a courtesy to one another. Now, if the ranking member asks for a subpoena and the chair disagrees, the ranking member can put that to a vote of the committee in an effort to require that.
Same as Nixon
that
and
was
same as
true
Clinton.
then.
Yeah.
That is true now. If the chairman asks for a subpoena and the ranking member disagrees, historically that would also have been put to a vote of the committee. That's not true here. There may be a functional reason.
These are under the rules you adopted, so maybe you might want to check with your past leaders as to why they did that.
But I'm asking you as the leader why we're doing that. That was not the way it was in 1998.
We thought you'd be happy.
You were here in 1998. I was here in 1998. These rules were not here in 1998. And I appreciate my friend from from Florida. I don't, there's not a functional difference. It just is that constant drumbeat of poke 'em, poke 'em, poke 'em.
Mr. Woodall,
Mr.
the
Florida.
Latin word that we use as a derivative, majority, it came from major. The Latin word minority came from minor. You understand?
I do.
All right.
I do indeed. I yield back, Mr. Chairman.
Mr. Perlmutter.
Yeah, and I appreciated Mr. Cole's comments that this is a bill about process. And we're talking about process, and we don't agree with the process that you're proposing, and obviously you don't agree with the process we're proposing, and we'll vote on that. But we wouldn't be here but for a memo that says we're going to hold up money for to a foreign government unless something is done to investigate a political opponent. We wouldn't be here but for an admission by the Chief of Staff of the President saying the same thing. We wouldn't be here but for a report by a special prosecutor that, in my opinion, details a number of obstructions of justice. And so, we can get into the weeds, and that precisely is what you've got to do when you're talking about process. But for the fact that all of these things have occurred, and going back to a conversation Dr. Burgess and I had, where we've asked for tax returns for years now, they've been refused, and my question is, so what's being hidden there? We've asked for financial documents for years and been refused, and this process is to get information, potentially present articles that we then all vote on. And then there's a second part, which is the trial in the Senate. And so I appreciate the gentleman, and in effect, there's an attempt to represent the president by your amendments. And that's okay, except that I think we are a separate branch of government and have a responsibility towards oversight, and if we think there's been an abuse of power or some kind of a flagrant disregard for the rule of law or some kind of we've imperiled national security, then we've got a responsibility, and that's what we're taking on through this process. And so I'm going to urge a no vote to the gentleman's amendment.
Would my friend yield for a point of clarity?
Sure.
I will tell my friend, as I think he knows, I'm not here to represent the president. I am here to represent fairness and due process. And whatever conclusion is reached by the Intelligence Committee or the Judiciary Committee, it is going to be colored by the details of what you and I do in this committee tonight. And why in the world either side would have a vested interest in tainting that final outcome is a mystery to me. But I just say, I'm not representing the president.
Reclaiming my time, the point is to finish it and get it done and not continue to go down this path and continue to, ask for something that the president says, I'm not giving it to you. And I'm going to appeal, and I'm going to appeal, and I'm going to continue to do some things. But this was all brought to a head by a memo detailing a lot of what, in my opinion, was not right. And this is a job that we have to finish and not delay any longer. And I think that the amendments that are being proposed lead to that. And that's why I'm going to oppose your amendment.
Before I just would say, look, I mean, we're going through this process because we want to bring some integrity to the House of Representatives, which has been totally disregarded by the President of the United States. We are interested in transparency and allegiance to our Constitution and to our country. This is a serious matter, and I am proud of the bill, the resolution that we have brought before this committee. I think it paves the way for the next step, and I hope that at the end of this debate, that people will vote for it. But the vote now is on the Woodall amendment. All those in favor say aye. Aye. Opposed, no? No. In the opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments. Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment at the desk designated as Cole number 10.
Clerk will report the amendment.
Amendment number 10 to House Resolution 660,
I would ask
offered by
that
Mr.
the reading
Cole.
be dispensed with,
Readings
Mr. Chairman.
without objection.
Thank you very much, Mr. Chairman. Mr. Chairman, the amendment simply removes the requirement that the ranking member of the Permanent Select Committee on Intelligence receive, quote, the concurrence of the chair before issuing subpoenas. Provide a level playing field for all parties, will ensure that the minority's rights are respected, will make sure that important witnesses and documents will be included in the record. Again, it's simply setting up the same standard for both sides.
Heard the Cole amendment. Any discussion? Mr. Raskin.
Thank you, Mr. Chair. I rise in strong opposition to the Cole amendment. As we've discussed, there was never any power in any prior impeachment for the minority to conduct subpoena power without or over the objections of the majority. It just has never happened. It would be completely unprecedented. I appreciated Mr. Woodall's candor in saying that this is not something that ever took place before. He's asking for a new adventure in lawmaking here. So I think that this is the wrong way to go, especially, I must say, as a member of the Judiciary Committee, at a time when there are members of the minority party who have pursued absolute wild goose chases on deep state conspiracy theories in an effort to distract from the matter at hand. What America is confronted with today, Mr. Chairman, is the president withheld $391 million in military and security assistance at a time when he was trying to pressure the government of Ukraine to give him information about political opponents. That is a shakedown operation. That is unprecedented in American history. That is a complete sellout of our foreign policy, a sellout of our Constitution, and it is a sellout, I think, of the 2020 presidential elections. That's what we're focused on, and there have been so many efforts to engage in irrelevant and distracting diversions from what the purpose of the inquiry is. So I think there is no reason to break from bipartisan precedent going back through every impeachment in which the majority rules in the committee, the minority's rights are completely protected. They can suggest as many witnesses as they want. In fact, I was just noticing in the last amendment by Mr. Woodall that he was saying that the ranking minority member should be authorized to request witness testimony from a number of witnesses equal to the number of witnesses requested by the chair. I think he can do that now. In fact, he or she could request more. You can request as many as you want. I don't think that you're limited to the number that you can request. Yeah, please. I'm happy to yield.
Thank you for yielding.
Yeah.
Say to my friend, in case it would have changed your vote on the last amendment, I wasn't asking for the ability to request. The ability to request is there already. I was asking that those requests would actually be granted up until the number that the majority had.
I'm sorry, I was just reading the language in C1, that the ranking minority member is authorized to request witness testimony. But so, in any event, look, let's not confuse the public about either what's happened up until this point or about what's happening going forward. Up until this point, and I've been in the room, the majority staff council gets an hour, and then the minority staff council gets an hour. And then they take turns for 45 minutes going back and forth. Half of the time for the majority, half the time for the minority, and then the members on both sides get to ask questions at that point. And so it's perfectly equal in terms of the allocation of time, and we're going to proceed along those lines. This is fair. Let us not confuse the public. We are proceeding in a way that the minority is going to be very well represented, amply represented in all of the proceedings that take place. And I do appreciate the candor of our colleagues who are saying they're asking for something more than Republican majorities gave during the impeachment of Bill Clinton. And we will give everything to the minority that the minority was given in that episode. I think we've given more in terms of the rights of the President's Counsel. But this is a step way too far to simply say that the minority can have its own subpoena power and can conduct wild goose chases into deep state conspiracy theories that have been thoroughly discredited and debunked. I yield back.
Mr. Cole.
Thank you very much. My friend talked a lot about precedent in his remarks. There's a lot in here that's unprecedented. It's unprecedented to deny a member the ability to grant his time to another member. It's unprecedented to draw up a resolution with zero input from the other side. That was not done under either Nixon or Clinton. So please don't appear with precedent saying we're asking for something unprecedented when the document itself is unprecedented. The manner in which it was written is unprecedented. The process in which we're proceeding is unprecedented. If my friends want to believe it's a good process, that's fair enough. You're certainly entitled to do that. But the processes in the Nixon and the Clinton impeachment were accepted by both sides. I suspect we'll see in the vote on Thursday that the process that we're proceeding under here is not accepted by both sides, and that's unprecedented.
And I just say to the gentleman, with all due respect, I'm willing to bet that there's no process that would be acceptable on the Republican side. But Ms. Lesko. Oh, Ms. Torres. I'm sorry.
Are you agree with the next vote or on this issue?
But I didn't know if you go back and forth.
We'll make sure everybody wants to
All
speak.
right, thank you,
right?
Mr. Chairman. I just need to respond. First of all, I support the amendment, but I just feel I need to respond to my colleague, Mr. Raskin. He said something to the effect, I don't know if I got it totally accurate, that he's alleging that the minority is doing these wild accusations, and that's why we can't permit them to subpoena people because we'll go off on this track. Well, may I say that I believe the majority has gone on some wild accusations. In fact, in judiciary, as we are in, I've spent since, January, and for 2 years, ever since President Trump has been elected, there's been accusations that he's colluded with Russia and conspired, and then the Mueller report said, no, that didn't happen. In fact, no U.S. citizen conspired with Russia to influence the 2016 election. And then, of course, you know how we sat in judiciary and supposedly the next thing was there was obstruction of justice, and then Robert Mueller came in, and that just kind of flopped. And so now we're switching to this Ukrainian phone call. And so what I would say is, I know we disagree. You think we have wild accusations? I think you really have wild accusations. So I don't think that's a good point. The other thing you said a couple times is let's not confuse the public. I totally agree, except we probably disagree on what we're talking about here. I mean, one of the titles, the subtitles in this bill, which I talked about before, let me get to the page, and this is regarding the Intelligence Committee, says Section 2, open and transparent. I mean, my goodness, you're still continuing these closed-door hearings that are not open and transparent. And in fact, we're just continuing the same thing where members can't even get copies of transcripts. Members that are on the committees can't even get copies of transcripts. So I would conject that. I agree with you. We need to not, deceive the public or confuse the public, but I contend that your title there and part of this does.
Ms. Torres.
So interesting how we could go back and forth and talk about process and how different things are. I think there are 5 words that will forever be written in our American history, and those are, but do us a favor. Do us a favor. We know you are under the gun and you need this money badly to protect yourselves, and we know that our allies are threatened in the region. but do us a favor. Investigate my political opponent, and then we will release the funds. Those words, but do us a favor, will forever be in our history, forever. So we can talk about process all we want, but that is not going to change the historic events that have occurred. So, you know, there's been a back and forth about the Mueller report. Let's talk about the Mueller report and how Democrats were denied that report for 3 weeks. Denied that report. We couldn't read it, we couldn't look at it, we couldn't participate in any of that. And then, when we were finally given a measly 2-page briefing of that report, that by far was not representative of the actual facts. So it is unprecedented that the investigator had to come out with a letter to correct some facts. So we can go back and forth, and we have all night to do that. I am prepared to be here, spend the night with you if that's what you want. But the back and forth is not going to change history. Do us a favor. And I yield back.
Mr. Chair.
Can I yield to Ms. Scanlon first, and you, Kashida? Ms. Scanlon?
Yes, I just wanted to speak to a follow-up on Mr. Raskin's statements. First of all, I strongly oppose the amendment at the desk. I support the resolution as written because it sets forth procedures for the House to consider whether we must issue articles of impeachment, and it does so in a way that respects the gravity and the seriousness of the situation. We've already seen far too many efforts to distract and to turn this into a circus. So I completely agree with setting the rules so everyone knows what they are as we move from the investigation stage into the consideration stage. It's a multi-stage process, and I'm just relieved to see that we've had some progress. Thank you.
Ms. Lesko?
Thank you, Mr. Chair. I just want to make sure that it's in the record that what my colleague, Ms. Torres, said was not an accurate conversation that President Trump had with the Ukrainian president. The only part that possibly is the same as the things do us a favor, but it had nothing to do with Joe Biden. And in fact, and then you just made up stuff. It's like Adam Schiff.
Would you yield when you finish, Ms. Lesko?
Yes, of course. It's just the same as the chairman, Adam Schiff, did. He just made up some made-up, make-believe testimony, and I think that's just what I heard here, and that's very upsetting. And so I just want to correct it for the record that those other things that you said were not what was said.
So I want to yield to Ms. Torres and then Mr. Hastings.
For the record, the president has admitted on national TV that he asked for assistance, that he asked a foreign government for assistance. Secondly, the president's personal attorney has admitted on national TV that they asked for assistance. So I am one that refuses to put my head in the sand and continue to ignore these horrible, horrible behavior. And with that, I would yield back.
Mr. Hastings.
Thank you very much, Mr. Chairman. Ms. Lesko, earlier in your presentation, you remarked words to the effect that the Mueller report did not reflect any collusion, and you were correct in that regard. What you did not say was that the Mueller report does, in fact, point to 8 instances of obstruction of justice, and that the reason that they were not pursued was because of a justice memorandum that disallowed the indictment of the president. Those obstruction of justice matters are still there in that report. let me give you the benefit of what is alleged to be the memorandum or the summary as offered by the president with reference to the language that Ms. Torres was talking about. It is quoted as, "I would like you to do us a favor, though, because our country has been through a lot, and Ukraine knows a lot about it." Trump then says, before floating the CrowdStrike investigation, he adds, and you said he said nothing about Biden. Here's what he is alleged to have said in the summary. The other thing, there's a lot of talk about Biden's son, that Biden stopped the prosecution, and a lot of people want to find out about that. So whatever you can do with the Attorney General would be great. Biden went around bragging that he stopped the prosecution. So if you can look into it, it sounds horrible to me. He did, in fact, say something about Biden. The more relevant thing to me is, why would they put the full statement of the call of the president with Mr. Zelensky into a private server that is the exclusive prerogative of the intel community? So those are the actual facts, as I understand them, and maybe you understand something different. Yes, ma'am. Thank you for your.
Very briefly, if you don't, I don't want to be here all night, but you know, if you're reading right from the transcript, I don't have a problem with that. What I did object to was, you know, just making up stuff. So that's what I was pointing out. If it was a summary, then so be it, but it was not the actual words that were said previously.
That's what Ms. Torres said. What I said were the actual words.
Yeah, so if I think the vote now is on the Cole Amendment. All those in favor say aye. Aye. Opposed, no. No. In opinion of the chair, the noes have it. Roll call. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9
The
nays.
amendment is not agreed to. Further amendments, Mr. Cole.
Thank you very much, Mr. Chairman. I'll be careful with this amendment. That one took us a long way in different directions that I had not anticipated. I actually thought it'd be pretty short, process-driven discussion, but this is somewhat similar. Mr. Chairman, I have an amendment at the desk designated as Cole number 11.
Clerk will read the amendment
Amendment number 11 to
Mr.
House
Chairman, I'd ask that
Resolution.
the reading be dispensed with.
without objection.
Thank you very much, Mr. Chairman. The amendment really adds the same consultation requirements for issuing subpoenas for the chair of the Permanent Select Committee on Intelligence and the chair of the Committee on the Judiciary as the resolution imposes on the ranking members of each committee. Again, we're just trying to make sure that it's a level playing field. Everybody complies with the same rules when they're issuing subpoenas. I think that's a fundamental fairness issue, and again, I think it would actually strengthen the resolution in question considerably. With that, yield back.
Yeah, and I appreciate the gentleman. Again, I just would say this is something that we did not have in the Clinton impeachment and in the Nixon impeachment. And does anyone else have anything to say?
Mr. Chairman, I could be reading the Cole Amendment incorrectly, but I hold in my hand the Clinton language here, which says clearly, subpoenas and interrogatories, such authority shall, of the committee may be exercised by the chairman and the ranking minority member acting jointly, or if either declines to act, by the other acting alone, except in the event that either so declines, in which case either shall have the right to refer to the committee for the decision of the question of whether such authority shall be exercised. It is a fact that what the Cole Amendment is asking for, that if the ranking member opposes, that the question be put to the full committee, is precisely what we offered in 1998. it is not threatening to the majority's exercise of authority at all, because you have the votes and folks vote in lockstep. I don't think for a moment, but to continue, as Mr. Raskin said earlier, that recognizing that we are asking for new things while the majority is doing things word for word the way they've been done in the past, just nonsense. Time and time again, in a nickel and diming kind of way, you continue to build into the process, for the first time in American history, advantages to the majority in this process. And Mr. Cole, time and time again, is giving you an opportunity to correct that in a way that harms you not at all, but improves the process substantially. And I'm just waiting for you to take yes for an answer.
Well, we're going to agree to disagree. Any other comments of Mr.?
Just quickly, if I may, Mr. Chairman, thank you for the indulgence. I wish I argued my amendments as well as my good friend from Georgia does. I'm going to miss my friend when he's gone, and I think this committee will miss us. But I think he caught the essence of it, which is, look, it's not that big a deal. This is, you still have the majority. You still could refuse and do whatever you want. It just says the same conditions apply. And so, again, as my friend made the point, we're not asking for something special. We're asking for an equal deal where you still hold the edge, you still would make the final decision. And I think that strengthens it. I think people would have more faith in the fairness of the process with these kind of things built in. So, again, thank you very much, Mr. Chairman, and I appreciate your consideration of the amendment.
Voters on the Cole Amendment?
But, Mr. Chairman, can I make one last
Yes, you may.
comment? It'll be brief. Just because folks, we have rushed this process here, and so folks haven't had a chance to look at these amendments. What this asks is that when the minority objects, that the question be put to the full committee, which of course the majority would win. It's the way we did it in 1998. The change is that individual members of the committee will not have to vote on actions that their chairman takes that the minority deems to be inappropriate. And I don't understand, unless the majority is as embarrassed by some of their chairman's behavior as the minority is, why it would be a problem to put every member of the majority on record supporting those actions. And that is the only thing this amendment asks for. I'm going to be curious to see what that objection is and how history records that. I yield back, and I thank you for your indulgence.
The vote is now on the Cole Amendment. All those in favor say aye.
Aye.
Opposed, no? No. Can you chair the noes have it? Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. Dusonier? Mr. Dusonier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Will report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Any further amendments? Mr. Cole? Will clerk report the total?
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments? Mr. Cole? Ms. Lesko?
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will read the amendment.
Amendment number 12 to House Resolution 660, offered by Mrs. Lesko. Page 6, line 5, strike is authorized and insert shall. Page 6, line 6, strike to transfer and insert transfer. Page 6, line 7, insert after records or materials the following, including exculpatory records or materials.
Thank you, Mr. Chair. Section 3, change authorized to shall or similar language to require the Intelligence Committee Chair and other committee chairs to provide all materials, including exculpatory materials, to the Judiciary Committee. So currently, in this resolution, Section 3 of this resolution is currently written, authorizes Chairman Schiff and the chairman of the other committees that have records or other materials that relate to the inquiry into the president to transfer those records or materials in consultation with the appropriate ranking member to the Judiciary Committee. Well, as we know, consultation does not mean in agreement. And as currently written, Chairman Schiff is the one deciding what materials and what evidence is going to be sent over to the Judiciary Committee. Therefore, the members of Congress, who will be the ones voting on articles of impeachment, including the entire Congress, but specifically first the Judiciary Committee, are not even guaranteed to have or see all the evidence for potential articles of impeachment. You know, how on earth are members, first in the judiciary and then the total full House of Representatives, supposed to vote on something as serious as articles of impeachment when we don't even have access to all the transcripts or to these closed-door hearings that are happening right now? This is really, in my opinion, absurd. We're talking about articles of impeachment for the President of the United States. There is no reason why anyone in this body should disagree that all materials must be transferred to the members of Congress on the Judiciary Committee. And, you know, I guess I'm going to ask Mr. Chairman a question. Mr. Chairman, would you feel comfortable if you're a member of Judiciary Committee and I wasn't even able to hear the testimony, and then I have to rely on whatever Mr. Schiff decides he's going to send over? I don't know if that's a complete testimony or not. And you want me to vote on articles of impeachment, something so important, when I wasn't even there, as was done in previous impeachment hearings? Would you feel comfortable with that?
Yeah, well, let me just say, I mean, I'm getting a little whiplash here, because first we were hearing that the committee should do nothing, and now we're saying the committee should do everything. But here's the deal. I mean, I guess what I would say is that there may be some material that is incredibly sensitive that, quite frankly, it would be inappropriate to pass to another committee, maybe a national security secret. I mean, I don't know. But I mean, there are some things in the Intelligence Committee that I, as a member, don't have access to. So I mean, I think we want to make sure that we're handling this in a way that is appropriate, that provides the maximum amount of information to the Judiciary Committee. But I mean, there may be some things that are highly sensitive that might be very, very difficult. So I guess that would be my response.
Well, and if I could respond.
Absolutely.
Mr. Chair, the thing is that all members of Congress, if there is classified information, although I've been told there's really no classified information going on in these SCIFs, but if there was, I mean, we all can go into the SCIF. Every member of Judiciary Committee could go into the SCIF and read these classified things. It doesn't have to be public. That doesn't mean I shouldn't be able to see them as a member of Congress and a member of the Judiciary Committee. I just think it's very unreasonable for me as a member of Judiciary Committee, and then as all of you, I mean, both Democrats and Republicans, to vote on something this important when we don't even know if we have the entire information, because it's all up to Chairman Schiff what he's going to put in the report to Judiciary. And then our own members on these committees can't even get copies of transcripts. I've put in a request for copies of transcripts and have been rejected. So, I mean, I just think it's unfair. And that's why I encourage us.
Mr. Chairman?
Mr. Burgess.
May I be permitted to answer the question that Ms. Lesko posed?
You can say whatever you want.
Well, we had Chairman Schiff and Brad Winstrup, Representative Winstrup, here in the committee when this story first unfolded in front of us. And Mr. Schiff brought in a hastily drawn-up resolution, that you wanted to vote on the House floor the next day that was pretty harsh. And I remember Mr. Woodall very eloquently stating that maybe we should just perhaps consider the Senate language, which is much less accusatory, and no one would have any part of that. When I had the opportunity to ask Mr. Schiff a question about the whistleblower, I was, say this correctly, but I don't think he took it seriously. He implied that I didn't understand what a whistleblower was or what the implications of a whistleblower's testimony was. But now we know that Mr. Schiff and/or his staff had been in direct communication with that whistleblower, and he did not disclose that day he was here on the dais in front of the dais in the committee. So the answer to your question is no. I would not trust Mr. Schiff to make those decisions on an issue of this importance. And yeah, I'll just like the rest of you, I represent 740,000 people back home, and I have to make a decision that I think is best for them. But if that requires me to trust anything from Mr. Schiff, the answer is no, thank you. And I'll yield back.
Mr. Woodall?
I want to offer an opportunity for folks to say yes one more time. Again, look at Section 3. All this amendment does, and it's not, folks have described this as a national security crisis. I made the amendment earlier to strike Ways and Means, to strike Energy and Commerce, to strike Oversight. That amendment was rejected. What the Lesko amendment says is, since you're tasking all of these committees with producing information, all of that information that the committees produce in search of truth, as we have described it here today, should be turned over to the Judiciary Committee for its consideration. I don't understand the controversy in that. The bill says folks are authorized to turn it over. I just assumed that they would turn over information. The addition that she makes is that exculpatory information should be turned over too. I've not heard one member of the majority say, what I'm here to do is railroad the president. Everyone has said they're in search of the truth. And so what could possibly be the harm of an instruction to turn over exculpatory materials to the Judiciary Committee as well? Shall transfer materials, including exculpatory materials. It's what you crafted 5 out of 7 pages to do, to gather this information. And Ms. Lesko suggests that if we're going to spend all the time gathering it, perhaps we should look at it. No one is talking about sources and methods. No one is talking about threatening national security. I promise you, folks are in consultation with the ranking member on the Intelligence Committee. Our ranking member has no interest in disclosing classified information. And that would be true on Ways and Means. It would be true on Energy and Commerce. It would be true on government oversight.
The gentleman,
My friend from Maryland.
he may have no interest in doing so, but if you put shall in there, he'll have to.
Shall transfer.
So but essentially, this is written, I think the amendment is written in such a mandatory way, it would include relevant materials and irrelevant materials. Material materials, immaterial materials, classified and unclassified. I mean, at what point do we leave it to the chair and the ranking member to do their job and participate in this impeachment investigation? I understand there are people who don't want to be part of it, but this is the way that it has to work. We got to get the relevant materials. We got to get things that relate to the investigation and not things that don't. And we don't want to breach the classified province of the committee. So I think it's a petty amendment, and I'm going to vote against it.
I think, my friend, and I recognize the place from which his comments come. Section 3 is included for one reason only, and that is to create the transfer of information. We are not trying to create the transfer of information. The majority laid out 5 pages of fact gathering and has 1 paragraph to turn those facts that were gathered over to the Committee of Jurisdiction on the Judiciary to hear them. This language, as you have drafted it, authorizes all of those committees to turn over everything. It authorizes them. Whatever the concerns were that we might have about national security, about privacy, by passing this resolution, we're going to authorize those chairmen to ignore those concerns. And it adds, collect all the information you think is damning, but turn over the information you think is exculpatory as well.
Well,
Shall turn that information over. I think my friend from Maryland would agree that authorizing the chairman to turn over exculpatory information would not be strong enough to achieve what we on the minority would want to achieve. I yield back, Mr. Chairman.
Yeah, and let me just say, there's another part of this here, that in the bill here, the Permanent Select Committee is directed to issue a report setting forth its findings, any recommendations, and appending any information and materials the Permanent Select Committee may deem appropriate with respect to the investigation described in the first section of this resolution. The chair shall transmit such report and appendices along with any supplemental minority additional dissenting views filed. Look, I mean, I think we've made I agree with what Mr. Raskin said. And let me just say, and again, I'm not trying to, question the motives of anybody here, but the bottom line is this. I think if my friends were really interested in trying to improve this bill so that it would be a better product that maybe more of them would support, and as I said before, I don't think you could ever get a bill that any of you would support, that maybe we would have received these amendments earlier, and we could have maybe, run the traps on them.
You mean when we received the language 24 hours ago,
Well, you know
we should
what?
have gotten
Yeah,
them to you even earlier?
You could have. You could have if you were serious about it. I mean, what we're having here now is like, kind of gotcha amendments, I mean, it's the first time we're seeing this stuff. And by the way, I mean, I understand what the point Ms. Lesko is making, but I think it's a poorly drafted amendment. And I think it is all-encompassing, and I think it could potentially, be dangerous to somebody. So,
No. May I'd like to make a point.
You may,
Chairman.
yeah.
Thank you very much. I mean, to say this is the first time you're seeing the amendments, I mean, it's 24 hours after we got the product. You're the ones that decided not to have a hearing. You're the ones that decided to do this all by yourself with not even a suggestion or an effort. So please don't complain about the amendments.
I'm not, well, I mean,
If you oppose the amendment, that's
Yeah,
fine.
no,
But we
do.
weren't given any chance
Yeah.
to have any input in the document. This is the only chance we have to discuss it. And, there could have been a lot of private discussions
Right.
here where maybe people wouldn't have drawn
Yeah.
battle lines
Right.
and we could have had some things. Again, I go back to simple things like letting members yield time to members. But the reality is, this is what we got. We didn't set up the process.
and
You
this is
did.
where we're getting, and so,
so
that's why we have some amendments I think are poorly written, and that may have some unintended consequences that I
again-
think even you wouldn't want to have happen.
Well, that's.
And I also think that we're not, this is not about improving the process or the bill. This, I mean, I think it's pretty clear, based on your leadership, that there's no process that is acceptable.
Well-
And I think that,
Chairman,
that's where there's a difference.
I'll take exception when you say, quote, even you.
I shouldn't say you, I should
okay.
I'm say,
All of us, okay, I guess that makes it better.
Yeah.
But, again, when we don't have an opportunity to have a hearing, when we're not involved in the input, then this is where we're gonna get. So this is our one shot, so we're gonna do
Fine.
the
Yeah,
best
we are
we
happy
can
to
the
be here.
time that we have. So with that, I thank you for your indulgence.
Ms. Lesko.
Thank you. Mr. Chair, I hope you know that when you call things poorly written amendments, as you have done previously, not at this meeting, but in the past, to me, that you do realize that these are like attorneys that are writing these amendments on staff. And so you're not really ridiculing me, you're ridiculing the staff. And so, if you think it's poorly written, but you agree with the premise of it, that, hey, all of this shall be turned over, I'm amenable to a secondary amendment if you are.
Well, let me clarify the record. I love the staff, and I respect the staff, and I respect everybody on this committee. But even on our side, there could be poorly drafted amendments. And so it's not meant in any other way to say that I think the amendment has unintended consequences. So with that, any other?
Chairman, I just-
Mr. Burgess, go ahead.
I'd just like perhaps engage Mr. Woodall or anyone else who would like to speak to it.
Do you want
But
to, yeah, you can speak to it.
If the prosecution withholds exculpatory information in a criminal trial, that would lead to a mistrial and a finding for the defendant, would it not?
Mr. Chairman. Okay. Let's restate some basics so people understand where we are. The House of Representatives acts as a grand jury and/or a prosecutor, if you will. We bring a case over to the Senate. The Senate, according to the Constitution, conducts a trial. In the case of the President, the Chief Justice of the United States serves as the judge in the trial. They make all evidentiary decisions over there. We've included a far greater panoply of rights for the defendant, if you will, and speaking analogously for the President, than any defendant gets in any grand jury investigation. And there will be a lot more in this one than there was in the last one with Bill Clinton. Bill Clinton was not able to get into the Ken Starr investigation when they were conducting depositions and
Reclaiming
questioning.
time, withholding of exculpatory information is not a good.
Okay, and the point I want to make about that is, okay, then if I would seek to be recognized, Mr. Chairman, if I could.
Yes.
Okay, so in the language the chairman read before, the minority has the right to bring forward in its dissenting report anything that it wants to bring forward which it thinks has been left out by the majority. And before the Judiciary Committee, the minority is able to make its claim for further evidentiary submissions if it seeks to do so. So there's no right that a defendant has before a grand jury to get exculpatory evidence before a grand jury or in an indictment or in a criminal information. It just doesn't exist. That would take place at the trial level. Nonetheless, we've included the full panoply of rights that the president has gotten in prior impeachments. So I don't see what the complaint is. I yield back, Mr. Chairman.
Mr. Who? Go ahead.
Well, except that there is testimony that is being taken in the House Committee, Select Committee on Permanent Intelligence, which is not in the purview. Most of us have not had the ability to see that. I don't know if we ever will, but I think Ms. Lesko's point is, if you've got exculpatory information, and it is in that committee that is outside of the public view, you're required to turn that over. And I think being against that is a bad look. I'm just trying to keep you
Mr. Burgess,
from looking bad.
Wait, I want to put your mind at rest here, okay? The resolution which you oppose will make all of those depositions available to all of us. They will be made public. You are opposing the resolution to make them public. So I don't know exactly what evidence you think you wouldn't have access to.
Well, so far, I've had access to none.
Okay, but I don't, if you want to file a complaint about you went down at the wrong time or something, do it. But the whole purpose of this resolution is to make it available to all of us. And I can't see for the life of me why you're complaining about that, why you wouldn't support it. That's the whole point of the resolution.
Okay.
Ms. Lesko?
I have to say something. Where do you see that it requires the transcripts to all be released to all of us? I don't see that anywhere. It authorizes it. It doesn't require it. That's the point of my amendment.
Yeah. What I like is someone to require the president to turn over the full transcript of his conversation with the president of Ukraine. That might be a good start here to move things forward. But any other questions? All right, with that, the vote is on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Ms. Morelli? No. Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Members not agree to further amendments. Ms. Lesko.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will read the amendment.
And
Amendment number 13 to
you
House
can dispose
Resolution.
of the reading,
Yeah.
unanimous consent.
Without objection.
Mr. Chairman and members, my amendment number 13 addresses page 6, line 2, change the language to the chair of the permanent select committee or the ranking minority member of another committee. And so basically, since we just rejected my last amendment, number 12, which said you shall turn over the information from these committees to judiciary committees. This is another attempt at doing that. I was hoping you would pass that one, and then this one wouldn't be necessary. But in a process that to date has been characterized by, I believe, unnecessary secrecy and violation of House rules and norms, it's important going forward to establish two things. fairness, and transparency. Ranking members from all the relevant committees should have the same ability to transmit materials to the House Judiciary Committee as the chairs. We want to ensure that the full story is heard and all the documents are made available to the Committee on the Judiciary. Consultation is insufficient for achieving this purpose. As currently drafted, the committee chairs could continue their pattern of selectively highlighting information that fits their preconceived narrative of impeachable acts by the president. This amendment would ensure that this outcome is not possible. It is regrettable that we find ourselves in a situation where rules and norms are not enough to ensure fairness and decency, but here we are. And so I ask for the support.
Mr.
You
Chair.
heard the Lesko amendment. Any comments or discussion?
Yeah, Mr. Chair, I remain unfortunately confused by this. As I read this on page 5 of the resolution, line 10, the Permanent Select Committee is directed to issue a report setting forth its findings and any recommendations and appending any information and materials the Permanent Select Committee may deem appropriate with respect to the investigation described in the first section of this resolution. The chair shall, not may, shall transmit such report and appendices along with any supplemental, minority, additional, or dissenting views filed pursuant to Clause 2.1 of Rule 11 to the Committee on the Judiciary, and make such report publicly available in electronic form with appropriate redactions to protect classified and other sensitive information. I gather, unless there is another way to say this, that this is shall, it's all the information, it's all the appendices, it is the minority report, it is anything else that's supplemental. And so we can go through pieces of it, but when you refer to this, which I think is the most operative section of the resolution, unless I miss it, I think this is all contained therein. There is no other thing here. And this would include exculpatory material as well as any other material, and gives the minority the free right to submit anything as part of the report. I mean, we can keep fighting and arguing about this, but it seems as clear as it could be to anyone reading this that that includes everything that has been described heretofore. So with that, I urge the defeat of the amendment.
Ms. Lesko.
Thank you, Mr. Chair. And I think Mr. Morelli was talking about the report actually being sent to Judiciary Committee by Mr. Schiff. I was talking about the documents not only from Mr. Schiff's committee, but also these other committees that you're asking to, saying, well, you could send them over, you give authority to send them over, but doesn't require them to be sent over. And so the last amendment basically said you shall send them over, and since that one was defeated, it says that if the majority, or if the chairman of that committee doesn't send over to Judiciary Committee all of the evidence, that then the minority member could.
Respectfully, I'll read further down here. The report required by this paragraph shall be prepared in consultation with the chairs of the Committee on Foreign Affairs, the Committee on Oversight and Reform. I mean, and therefore the minority material that would go with it would all be included in it. I know the hour's late and we're arguing about words, but everything that you've suggested that you wish to make public, with the exception of classified material, is going to be included here. And in my view, there's almost no other way to read this, and there would be no way for the chair of the committee to exclude minority findings and minority reports, exculpatory or otherwise.
Would the gentleman yield?
Yes,
I'll yield to you.
Yeah.
I'll be brief. We've had this discussion many times tonight. The language you read makes no demands on the Committee of Financial Services, which this resolution authorizes to collect information. The language you read makes no demands on the Committee on Ways and Means, which this language authorizes to participate in this investigation. The language that Ms. Lesko offers achieves exactly the goal that you have read that other committees will be achieving, but these two, again, for reasons that are not clear to me, why you all added them in here, she provides the same disclosure from those committees that you have just lauded from the committees in your list. And I yield back.
Mr. Promoter.
Well, if the president would ever disclose those documents that Ways and Means has asked and the Financial Services has asked, then we might turn them over, but we don't have them to turn over.
Is that a quid pro
And-
quo, Mr. Perlmutter? As it
No, it's
sounds
not a
like
quid-
it.
No, it's not a quid pro quo. I mean, that's the problem, is the refusal to have witnesses testify, to turn over documents, just leads to, everybody asking, what's being hidden here? There's been lots of comments about the secrecy. Well, the secrecy, you got Democrats and Republicans down in that skiff asking questions equally, time and time and time again. But over down 1600 Pennsylvania, no, don't testify, don't turn over documents, withhold. And that's the problem we face, and I'd urge a no vote.
The vote is now on the amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9
Amendment
nays.
is not agreed to. Further amendments. Mr. Burgess, Ms. Lesko had a hand up. I don't.
This is like financial services, they just kept coming.
No, I think Ms. Lesko had her hand up first.
All right.
Thank you, Mr. Chair. I have an amendment at the desk, and you can,
Clerk will designate the amendment
and you
Amendment
can
number
dispense
14.
of the reading if unanimous consent.
without objection.
Okay. This is, Mr. Chair and members, another stab at the same subject, since the other two were rejected. It would add concurrence of the ranking minority member, and if there is no concurrence, it goes to the committee for a vote. So Section 3 of the resolution, as currently written, authorizes Chairman Schiff and the chairman of the other committees that have records or other materials that relate to the inquiry and to the president to transfer those records or materials in consultation with the appropriate ranking member to the Judiciary Committee. Consultation, again, does not mean an agreement. And as currently written, Chairman Schiff is the one deciding what materials and evidence to send over to the Judiciary Committee. We need to ensure that this process is handled fairly. We need to ensure the chair and ranking members agree on what information is imperative for the Judiciary Committee to have. And this is all my simple amendment ensures.
Thank you. Anybody want to say? The vote is now on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. And the clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments. Mr. Burgess.
Yeah, I have an amendment at the desk, number 16.
Clerk will designate the amendment.
Amendment number 16 to House Resolution 660, offered by
Unanimous
Mr.
consent, we
Burgess.
dispense with the reading.
Without objection.
Thank you. This amendment states that an employee of the House Permanent Select Committee on Intelligence cannot be a consultant. Section 2 of the resolution allows the chair and the ranking member of the House Permanent Select Committee on Intelligence to question witnesses for a period beyond 5 minutes and may designate an Intelligence Committee employee for this task. This amendment simply clarifies that this House Permanent Select Committee on Intelligence employee designated to question witnesses cannot be a consultant.
You heard the gentleman's amendment? Any debate or discussion? Ms. Lesko?
Yeah, briefly, this came up in Judiciary Committee where there was a I think he was paid, a paid consultant that was allowed to question witnesses, if I remember, and, members weren't even allowed to do it. And so I don't know why we're prioritizing consultants and, quite frankly, staff over duly elected members. And so I support this amendment.
So my understanding from legislative counsel is that, from House administration, is that employee does not mean consulting. In this context, does not mean consultant. So I'm told that the amendment is not necessary.
Well,
No, I mean, I think it's already in the bill. Yeah. But let me, again, let me remind everybody why we're here, right? I mean, we're here because there are serious allegations that the President of the United States endangered our national security. And, and it is a little frustrating to kind of hear all the, complaints about process, which, by the way, I stand by this process. I think it's a good process. The real sham process, quite frankly, is coming out of the White House. I mean, instead of respecting the constitutional authority of the House of Representatives, the White House has, as I said before, obstructed our investigation, ignored our duly authorized subpoenas, withheld relevant documents, prevented witnesses from testifying, and intimidated witnesses. They tried to disparage members of Congress who are trying to fulfill their responsibilities under the Constitution of the United States. As I said at the beginning, I'm going to repeat again so that people don't lose this context. Article 1 of the Constitution gives the House the right to investigate the President. And we're taking our responsibility seriously. And that's what this resolution is all about. I mean, what we know, based on what this President has admitted, based on what his acting chief of staff has admitted, based on the testimony that we know that has come out of the Intelligence Committee, I mean, this is serious stuff. And so, we can, some can continue to try to circle the wagons around the White House and make believe there's nothing there. But I don't know by any measure how people cannot be shocked by what's going on. And so, in any event, I just thought it was appropriate at this point to remind everybody of what's going on. Ms. Lesko?
Thank you, Mr. Chairman. I'm glad that in this committee you feel that it definitely is the rule that an employee can't be a consultant, but I'm telling you, it happened in Judiciary Committee, so when I was there.
I said in this context.
Oh.
In this context.
Thank you.
Yeah. Mr. Cole.
Thank you very much, Mr. Chairman. Just to get on the record, what we do know is that no investigation took place in the Ukraine. What we do know is the military aid arrived at the Ukraine. Those are things we actually know. And so other things we conjecture or people can talk about, and that's fine. We have a process. We'll go forward with that. But what we know is, again, no investigation took place in Ukraine, and what we know is the aid was actually sent there. So,
well, okay. Yeah. All right. So now the vote is on the Burgess.
Mr. Chairman?
Mr. Woodall.
Thank you, Mr. Chairman. To follow your lead, I would also like to remind everyone why we're here. Yeah. And we're here for one reason and one reason only, and it is not to be the fact finder, as you have just laid out. It is to create a process for other committees that are the fact finder. And I tell you, we sit in this committee hour on end together, night after night, voting 9-4 against one another. We have one responsibility and one responsibility only, and is to create a good process for the House of Representatives. And to constantly be denigrated on our side of the aisle for offering amendments to improve the process, when the only reason this committee exists is to create a process, I find to be troubling, particularly on an issue of this import. If we were talking about naming a post office, I'd find it troubling. But on an issue of this import, do I want you to move forward in the way that you're moving forward? I don't. Yeah. I think it's flawed, and I think it's destructive to the Republic. But do I want you, if you are going to move forward, to have crafted a process that builds as much trust and confidence in the American people as you possibly can? I do. And common sense change after common sense change after common sense change that does nothing to derail the freight train of accusations that the majority has going on, you have rejected and in many cases belittled as just being about the process. I wanted to be chairman of this committee, and I blame you all for not giving me that opportunity. But I wanted to be
I
chairman
would
of
have
this.
been off the committee.
I wanted to be chairman of this committee because I believe process matters. And a flawed process is going to produce a flawed product every single time. I hear it back home on a regular basis. Oh, Rob, it's the Rules Committee. All they do is process. That's true. All we do is process. And yet, we're the Speakers Committee and the Leaders Committee because process is that important to what this institution does every single day.
Can I make one point? Would you?
Sure, let me just,
Absolutely.
first of all, I didn't denigrate, I'm not denigrating anybody. I mean, you can do whatever you want. I'm trying to imagine you as chairman of this committee because I served with you when I was in the minority, and I didn't know where that, magnanimous approach to a more open process was. But I will say this, I believe that what we have before us is a good product. I know you don't, but I do, and I'm proud of this. And I think that our duty is, to the Constitution and to the people of this country. And I think the situation we find ourselves in, I have no idea whether this will lead to the filing of articles of impeachment. That is something that will be determined ultimately by the Judiciary Committee. But just speaking for myself, I am so deeply disturbed by this president's behavior and by what we know already, based on what he has said, based on what his acting chief of staff has said, based on the testimonies that have been made public coming out of the Intelligence Committee, that I think it demands us to move forward. And so if I'm denigrating people, and Ms. Lesko, I'm sorry, I was dismissive of your previous amendment. I'm just a little tired. I really apologize for that. But I'm just, I think we're all expressing our own frustration here. But I think that this is a serious moment in our country, and I don't think it's about, Joe Biden or Hillary Clinton. I think it's about what we know that this president has already admitted that I think is very, very disturbing. Mr. Chairman. I promise you, Mr. Cole, for us.
Well, I certainly yield to my friend.
What do you think?
Distinguished Vice Chairman. Well, I just actually wanted to be a little lighter note, and since our friend has admitted he at one point wanted to be chairman, I just wanted to publicly say if he'll refile for office, I will be happy to get out of your way and move you at least one step closer, and maybe you could jump over all the way if we have a good election. But I value my friend that much. I would share that ambition, and if you'll run again, I'll do everything I can to make sure you are chairman of the committee, and I'll go back to appropriations where I belong.
No, but, we believe it or not, we will miss Mr. Woodall when he leaves, but we're still blessed with you for another year. All right, thank you. Mr. Hastings.
Yes, Mr. Chairman. Mr. Chairman, I think it would be helpful recognizing that we have a Game 7 of the World Series, and I would hope members would not mind me providing a bit of clarity with reference to what it is that we are doing. This resolution makes clear that the investigating committee the committees have been engaged in impeachment inquiry and directs them to continue their vital work. I brought that up earlier when I pointed to the fact that they were involved in ongoing investigations. The resolution authorizes the Intelligence Committee to make transcripts of their recent depositions public with appropriate redactions made for classified or other sensitive information. It also establishes procedures for all investigating committees to transmit their evidence to the Committee on the Judiciary for use in their proceedings. And I might add a footnote there, a report will be prepared in each of the committees, and the minority will have an opportunity to offer a minority report, as time and again we have seen here with legislation. The resolution permits staff counsel
to follow their lines of inquiry to their ends by allowing for periods of up to 45 minutes per side in the questioning of witnesses. This approach builds on the precedent of having staff counsel conduct initial questioning, followed by member questions that Republicans set for the questioning of independent counsel Kenneth Starr in 1998. And just to make it extremely clear here, what Kenneth Starr did is not to be applauded. What Kenneth Starr did was egregious and very, very destructive to this process that we continue to refer to. I felt so strongly about it at the time, and I would urge you all to go back and look at the record, and you will see that I moved on the privilege resolution to impeach Kenneth Starr. It was, of course, tabled because the majority tabled it. The resolution also continues the precedent of giving the minority the same rights to question witnesses that the majority has, as has been true at every step of the inquiry. The resolution establishes opportunities for the president or his counsel to participate in impeachment proceedings held by the Committee on the Judiciary, including to present their case and respond to evidence, submit written requests for additional testimony or other evidence, attend hearings, including those held in executive session, raise an objection to testimony given, and cross-examine witnesses. If the president unlawfully refuses to cooperate with congressional requests, the chair shall have the discretion to impose appropriate remedies, including by denying specific requests by the president or his counsel. And if I were drafting this particular matter, I would make it the same article that had appeared in the Nixon impeachment, where it was referenced that the president had failed to cooperate with Congress. And this one certainly has done that. Following the precedent of every modern impeachment inquiry, the Committee on the Judiciary will recommend whether articles shall be reported to the House, which also none of us know what that result will be. I'd hope not to inject my personal prerogative into this proceeding, but apparently I deem it at this point to be particularly helpful. I've had very little to say about this overall process. There have been 19 impeachments in the United States of America, and I was one of those. If you all want to talk about fairness, I would invite you to spend about 6 weeks with me telling you about a 2.5-year investigation that was conducted in secret by the judiciary pursuant to 28 U.S.C. 372, a new law that came into existence at the time that I had been found not guilty in a court of law. There's nobody on this committee that knows as much about impeachment as I do. And for all the talk that you all are going on with about fairness and unfairness, please believe me that when the process began, the same things that are set forth in this resolution, plus the same things in the Clinton and the Nixon impeachments, were afforded to me. I had an opportunity at the United States Senate to be tried. In that trial, I was given an opportunity to present exculpatory evidence. I was given an opportunity to present anything that I deemed appropriate from my side. Were there things that were hidden from me that I didn't find out until after I was removed? Or perhaps that is why I'm here now. Be careful what you wish for, my friends. What you may find is that there's going to be more that we are going to have to deal with. I yield back my time.
The vote now is on the Burgess Amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings?
No.
Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
The amendment is not agreed to. Are there further amendments? Sure. Yeah. And before you proceed, I just want to I just want to take this opportunity to thank the staff in particular, who have worked so incredibly hard. Don Sisson has led the majority staff. Kelly Dixon has led the minority staff, and while we're all up here, I mean, all of the people around us have been working nonstop. And while I don't support your amendments, I'm impressed with the incredible staff that is on your side. I also want to congratulate Jennifer Belair, who's back here. She just came from maternity leave, and with her has a new baby girl, Violet. She came back early to do this, so that's beyond what is required of anybody. So thank you for being here.
Just if I may, Mr. Chairman, with Violet, we got finally another member of the Rules Committee staff. This is much better. We didn't have to pay. Our budget's limited, as you know. But I want to echo your remarks and again apply them to both sides of the aisle. We all know we have extraordinary staff in this committee. We all know how hard they work, how well they cooperate with one another and do their jobs professionally. And I also want to compliment you, Mr. Chairman. This is a contentious subject. We do disagree on this. You've been very patient in offering time. You've given everybody an opportunity to make the points that they felt like were important to be made. And while we won't come to the same conclusion on this, I think you've handled your responsibilities here in terms of presiding over the committee professionally and fairly, and for that, we thank you.
Mr. Woodall.
I have an amendment at the desk, Mr. Chairman, against that wonderful backdrop that Mr. Cole has just laid out.
Clerk will designate the amendment.
Amendment number 17 to House Resolution 660, offered by Mr. Woodall. Page 2, line 15, strike an open hearing and insert open.
In case anyone blinked their eyes for that period of time, Mr. Chairman, all this amendment says is strike an open hearing and insert open. As folks have talked about how proud they are of the process, how this is opening it up to the American people, how this is providing transparency, how we're doing all of these things. And in this 7-page resolution, 5 pages are dedicated to the Intelligence Committee. This document requires that the Intelligence Committee, again, which is tasked with the lion's share of this, hold an open hearing. I don't believe it satisfies anyone's definition of open and transparent, Mr. Chairman, anyone on this dais, to say that the committee that's tasked with the lion's share of the investigation, as long as they hold one hearing in public, the American people have been well served and well informed. I don't believe the Intelligence Committee should be the leader, and offered that amendment earlier. I was defeated. I don't believe the Intelligence Committee should be the leader precisely because so much of what the Intelligence Committee is closed, and the nature of reversing a presidential election in America shouldn't be done behind closed doors. The Intelligence Committee needs to do its work. It needs to do work related to intelligence and national security, but we've tasked it with impeachment today. Surely the majority would agree that the resolution about which they are proud, the resolution that is to provide that transparency and openness in this process, cannot include a definition of success that is a single open hearing in which the American people can participate. Page 2, line 15, reads, in its mandate to the Intelligence Committee, the chair of the Permanent Select Committee shall designate an open hearing or hearings pursuant to this section. The openness resolution is satisfied by a single ray of sunshine in the Intelligence Committee. That is unbecoming of this institution, and I believe my friends in the majority will agree with me on that. I yield back.
Well, let me first of all thank you for pointing out the fact that there'll be an open hearing. And I'm willing to bet there'll be many hearings, and I think that's the expectation. But, I opposed the amendment, but but we are moving toward an open process where we're going to have an open hearing. And so the concern about everything being done behind closed doors hopefully will go away. Mr. Morelli?
So just to be clear, this would be, you're suggesting there'd be 2 open hearings?
If the gentleman would yield.
I mean, that would satisfy your amendment? 2 open hearings?
If you doubled the transparency that you're currently offering America, I would consider that a step in the right direction. Would I consider it satisfactory? I would not. But again, the bar you've set for America is a single open hearing. I believe America deserves better.
Well, I don't think it
I think
does
that's about
that.
what
I frankly think you'll be crying at some point that we have too many open hearings. I don't think that's
The gentleman would like to make a
challenge.
friendly amendment to put a specific number of open hearings in here.
No,
would
I think
welcome
it's- I think-
that amendment.
Well, I would just say, and I have enormous respect for you, Mr. Woodall, and enjoy very, very much your presence on this committee, and always appreciate discussing issues on the floor with you as well. But I do think this borders a little bit on silly. It is an open hearing or hearings, obviously the discretion of the committees. I suspect there will be multiple open hearings, and so I would urge the defeat of the amendment.
Mr. Raskin, did you have a? Oh, okay. Anybody else?
If I have the right to close,
You can close,
Mr. Chairman.
You can open and close.
I agree with my friend from New York. It is just silly. It is just silly that when we're having a conversation about reversing the will of the American people in a presidential election, that we would have included in the resolution that we direct a committee to have a single resolution. I don't know who the lawyer was who stuck that in there. I'm with my friend from New York. That's ridiculous. We should have lots of hearings. My chairman said, I expect we're going to have lots of hearings. Now, if you want to know why folks are suspicious on this side of the aisle, I go down that dais to a member. Folks are going to tell me, Rob, don't worry, we're going to have more than one hearing. And yet, when I demand a recorded vote to a member, folks may well say, but I'm not going to require it in the resolution. My chairman said this is a serious moment in our country, and we can't even agree in a bipartisan way that one open hearing fails our responsibility, not just to our constituents, but to the document to which we swore an oath, the Constitution.
Mr. Chairman.
Mr. Raskin.
Thank you. I want to respond to 2 things. One is, I'm very glad that Mr. Woodall, whom we all admire and esteem, is conceding that we now have an open hearing requirement. That's great, that the world can see that there are going to be open hearings. Now, why do I put it in the plural? Well, one, I'm with all of my colleagues in believing that the majority is going to have not one, but multiple hearings in HPSI, but I am certain we are going to have open hearings in judiciary and in all of the other committees that members on your side of the aisle were complaining about having hearings related to investigating the high crimes and misdemeanors and misconduct of this administration. So there will be a lot of hearings, in the plural, a lot of multiple hearings. The other thing I just wanted to note is you stated 2 different times, Mr. Woodall, that impeachment would reverse a presidential election. I think you said the first time. The second time you said reverse the will of the American people. That is not the way that the framers of the Constitution conceptualized this, for several reasons. If I might, let me just lay it out. And
I could see the gentleman is correct.
Okay, then I will yield back, Mr. Chairman, and I'll accept that.
The vote now is on the Woodall amendment. Those in favor say aye. Aye. Opposed, no. No. Any of the chair, the noes have it? Roll call, please.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments. Mr. Burgess.
Desk.
The clerk will designate the amendment.
Amendment number 18 to House Resolution 660, offered by Mr. Burgess.
Unanimous consent. We dispense with reading.
Without objection.
Thank you, Mr. Chairman.
The clerk will, Gentlemen, proceed.
This amendment states that nothing in the resolution should be construed to diminish the rights of all members to fully access committee records under Clause 2E2 of Rule 11. Under the current rules of the House, the committee records are the property of the House of Representatives. All members have ownership over these records, and their access should not be obstructed. And yet, Chairman Schiff refuses to grant access for non-intelligence committee members to view the interview transcripts that are being used to support this impeachment investigation. To date, the Intelligence Committee has received 72 bipartisan requests to view Ambassador Volker's October 3rd, 2019 interview transcript. I sent one of these requests, along with a letter to Speaker Pelosi requesting access to all proceedings, transcripts, materials, and other records informing the impeachment inquiry. Chairman Schiff has refused to schedule a business meeting to consider these access requests. I understand the sensitivity of classified information, and I'm willing to comply with the conditions for viewing. Despite this, non-intelligence committee members are being blocked from viewing the information upon which we will eventually have to vote should articles of impeachment be reported to the Judiciary Committee. This is an important amendment clarifying that under Rule 11, Clause 2E2, that all members should have full access to committee records generated as part of the impeachment investigation. And Mr. Chairman, I have copies of letters that I have sent to Chairman Schiff and the Speaker of the House asking for this access. To date, I have not received a response, but I will be happy to submit these for the record and ask unanimous consent they be made part of the record.
Without objection.
Thank you.
Let me just respond by saying that the resolution provides a process for the entire public to see transcripts. It provides for open hearings. It provides for a report that will be publicly released. I think what is in this report is an appropriate and transparent way to move forward, and I would urge a no vote on the gentleman's amendment. I don't know if anyone else has anything they want to add. Hearing none.
Well, Mr. Chairman, it does seem that you're skipping our access as members of this House. In fact, we've had your resolution for a little over 24 hours. And this was my worry after going through that process we went through with the resolution that Mr. Schiff brought to us a month ago, and we had that hasty meeting up here, and eventually you all did concur to the Senate language, which I thought was the correct thing to do. But I'm being asked to make a decision about voting on a rule to bring to the floor of the House of Representatives a resolution authorizing the impeachment of a president of the United States, and I've had no access to look at any of the information that has been gathered over the last 34 days. I've asked for it. Other members have asked for it. Transcribed interview from Ambassador Volker should not be too much to ask for a duly elected member of Congress to have access to that before rendering an opinion on this resolution tonight, and certainly anything that might be brought to the floor as articles of impeachment.
Mr. Raskin.
Mr. Chairman, every member of the House of Representatives is going to have access to all of the relevant evidence before we're asked to vote on impeachment, of course. And I think that Mr. Burgess properly sets the right standard. Will, before being asked to vote on impeachment, if it were to come to that, will we have access to the evidence? And absolutely we will. That's the whole purpose, or a large part of the purpose of this resolution. The reason why Chairman Schiff has wisely decided to be very careful about who gets access to the depositions is to prevent witnesses from coordinating their testimony. Remember, this is the first line cut at getting witnesses to come in. So we want to both control the problem of leakage to the public, and we also want to prevent witnesses from coordinating testimony. But none of us will be asked to vote on any of this before there are complete reports written and evidence from both sides, the majority and the minorities, made available to every member. I yield back.
Ms. Lesko.
Thank you, Mr. Chair. I hear all these assurances that all of the transcripts will be released, but we're voting on this resolution, and on page 5, starting on line 3, it says, the chair, and we're talking about Adam Schiff now, is authorized. It doesn't say required. It says authorized to make publicly available in electronic form the transcripts of depositions conducted by the Permanent Select Committee. So that's our point. It just says authorized. If you're all convinced that they're going to release all of it, then why aren't we changing it? I mean, I'm sorry, but we're voting on this. We're not voting on, this is what I think is going to happen. And so,
I'm sorry, go ahead.
no, I'm finished, Mr. Chairman. Thank you.
Mr. Perlmutter.
Yeah, I didn't want to wade back into this because, you know, this isn't Watergate where there was a burglary. This isn't an infidelity in the White House. This involves the intelligence community. This involves the spies. This involves military aid. This has people's lives at stake. You know, we've had testimony from decorated war heroes on this thing. And the demands, and I appreciate this question about the process and stuff, but we also got to step back and say, this is very different. The scope of it is so much bigger than anything we've ever seen before. Whether you think it rises to the level of impeachment or a conviction in the Senate, but this is very different. And I appreciate my friends wanting to probe and get more information out of the Intelligence Committee, but people's lives are at stake here. This is not a burglary. This isn't an infidelity. I yield back.
I just would,
Mr.
again,
Bridges.
submit that these records are property of the House of Representatives, and as members of the House, we should have access to those records.
The vote is now on the Burgess Amendment. All those in favor say aye. Aye. Opposed, no? No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Are there any further amendments? Before we proceed, let me yield to Mr. Cole for any final words of wisdom.
Obviously, we're sort of like the Nats tonight were a few nights ago. We didn't get a lot of hits here, score a lot of runs. I think we're 0 for 18. Mr. Chairman, again, I have enormous respect for you. I have enormous respect for my colleagues. We think a lot of these amendments should have been made in order. We think they would have strengthened the process. We think they would have made it easier for you to defend the process on the floor tomorrow. We do think there's a lot of micromanagement in here of what are appropriate powers for members. We do not think this has been an open, transparent. I regret very much we didn't have a chance to discuss this before we saw it. So some of our concerns, you might have disagreed with them, and that would have been perfectly fine. Others, you might have said, you know, that might not be a bad idea. Let me think about that. We didn't have any of that. So we're going to the floor with a process that we had absolutely zero input in, other than tonight. And tonight, we can get a single one of 18 amendments. So I know you're proud of the process, and I respect you enormously as the chairman of this committee and as my friend. I'm not pleased with the process. I do not see it the way that you do, and I suspect that most of our colleagues will not see it that way come tomorrow. And so the sad thing for me is we will begin, which, by the way, the impeachments of Nixon and Clinton did not begin with partisan process. They began with a process that had been negotiated that both sides worked together on, and they did not disagree with the process. They might have fought over the deal, but we're starting in a very different place. And I think that place will lead us, I respect your judgment. You don't know what's going to happen. None of us do down the road. But my suspicion is that we will end up with a partisan impeachment vote. We'll have a partisan process vote tomorrow, a partisan impeachment vote probably later this year. I would hope not, but that's just my guess looking forward. And that will set the stage for something very similar in the United States Senate, in my view. I regret that. I'm an appropriator. I'd like to be getting appropriations bills done. I know you would too. No, I do. I just know once this horse is out of the barn, everything else, I'm on the Defense Appropriations Committee. I'd like to see a defense authorization bill done. I'd like to see USMCA come up. There are a lot of things, and there are things we could actually work together on. This will, at the minimum, delay, and I hope not, but potentially derail a lot of that stuff. So, but I think an open process or a different process would have been better. So, again, that's our views, but it does not diminish my appreciation for the manner in which you've run this hearing, for our ability to offer the amendments, your willingness to listen to everybody's argument. I think you've been extraordinarily generous in that and with the time. And so, again, we'll move forward from here and look forward to continuing to work with my friend even when we disagree. But disagree here tonight, we very much do.
Well, let me say, first of all, I want to thank you, Mr. Cole, because, you're a great partner on this committee, and I want to thank my Republican colleagues as well. I mean, we have strong disagreements here, but this committee did not disintegrate into all-out chaos, which has become all too common around here. And I want to thank my colleagues on the Democratic side, and again, the staff for all the work that they've put into this. Look, as I said at the beginning, I didn't run for office to do this. I didn't run to impeach a president. I ran to help pass appropriations bills and to help bring jobs to my district and to lower health care costs and end hunger in the United States and around the world. But these are very serious times. And as I said at the outset, I mean, I really do believe that they're so serious that 5 or 10 or 20 years from now, people are going to ask, what did you do? I mean, the allegations against this president are very, very serious. I mean, they are, he potentially endangered national security. And, his acting chief of staff admitted to a quid pro quo when it came to military aid. Then he denied it, but then he admitted it first. I don't know how all this is going to turn out, but I do know that these are very, very serious matters. And we need a process in place so people know how we're going to proceed. I think this is a good, transparent process. I know it's controversial, but I, for one, am proud of what we're putting forward here. And so, Mr. Raskin?
Mr. Chairman, thank you for your indulgence. You thanked the staff here, which does an extraordinary job both for the Republicans and the Democrats, and you've saluted our colleagues. As someone who has sat through, I think, almost all of the depositions as a member of the Oversight Committee, I also want to say that there's extraordinary courage being displayed by the public servants who are both civilian and military who've come forward to testify against and over the threats and the obstructionism of the White House, which has tried to stop people from testifying. And that's been a very impressive thing to behold those public servants who've come forward to do their duty and to render honest testimony.
Can I ask you a question, Mr. Chairman?
Yes.
Since you didn't run to do this, and I didn't run to do this, maybe you'll help me persuade Mr. Woodall to run for Congress again, because he did run to do this someday. And I don't predict the time, but if he stuck around, that time might come, and he's a very valuable member of this committee, a very good friend.
We love him, but we're happy he's not running.
That's a rare shaft of honesty.
Anyway, if there are no further amendments, the question is now on the motion to order the measure reported favorably to the House. All those in favor will say aye. Aye. All those opposed, no.
No.
In the opinion of the chair, the ayes have it. The motion is adopted.
Mr. Chairman, we'd like a roll call on that.
A roll call has been requested. The clerk will call the roll.
Mr. Hastings. Aye. Mr. Hastings, aye. Mrs. Torres. Mrs. Torres, aye. Mr. Perlmutter. Mr. Perlmutter, aye. Mr. Raskin. Aye. Mr. Raskin, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Morelli. Mr. Morelli, aye. Ms. Shalala. Aye. Ms. Shalala, aye. Mr. DeSaulnier. Mr. DeSaulnier, aye. Mr. Cole. No. Mr. Cole, no. Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. No. Mr. Burgess, no. Mrs. Lesko. Mrs. Lesko, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk report the total.
9 yeas, 4 nays.
The motion is adopted, and without the objection, the motion to reconsider is laid on the table. And I will be managing this for the Democrats. And without objection, the committee stands adjourned.